Good morning, everyone. First, let me introduce myself. My name is John Cronan. I'm a federal judge in New York City. I'm on the U.S. District Court for the Southern District of New York, and it's really a thrill and pleasure to preside over this final round. Let me echo what Ms. Francis just said. Tremendous congratulations to all of you for making it this far and all the other teams who participated. It is an incredible accomplishment. So let me call this session of the Supreme Court of the State of New York to order, and I'll ask the parties to introduce themselves. I'll start with the prosecution.
Good morning, Your Honor. My name is Christopher Machin, and I'm an attorney representing the people of the State of New York in today's proceedings. May I have an opportunity for my co-counsel to introduce themselves?
You may.
Good morning, Your Honor. My name is Emily Geller, and I'm also an attorney representing the people of the State of New York in today's proceedings.
Good morning, Ms. Geller.
Good morning, Your Honor. My name is Angie Hernandez Ramos, and I'm also an attorney representing the people of the State of New York in today's matters.
Good morning, Ms. Hernandez Ramos.
Your Honor, we also request that our witnesses introduce themselves as well.
That would be great, Mr. Mason. Thank you.
Good morning, Your Honor. My name is Isabella Correcchia, and I will be portraying the role of Fran Ashcott in today's proceedings.
Great. Good morning, Ms. Correcchia.
Good morning, Your Honor. My name is Sophie Lasserson, and I will be portraying Sharon Holmes in today's proceedings.
Good morning, Ms. Lasserson.
Good morning, Your Honor. My name is Nina Fischilla, and I will be portraying Pat Nolan in today's proceedings.
Great. Good morning, Ms. Fischilla.
Your Honor.
Yes.
Your Honor, we have a team-specific roster for yourself that we can provide in the chat if you would like.
I think I'm okay. I have a roster here for both teams, so I should be fine with that. And Mr. Macon, in terms of all backups or alternates in the event of any video complications?
Yes, we do have our backups ready to go here.
Great. Great. Well, let me hear from the defense now.
Good morning, Your Honor. On behalf of the defense, Shawn Miller, my name is Odelia Bergner-Phillips. I will be delivering the opening statement, conducting the cross-examination of Sharon Holmes, and conducting the direct examination of Nikki Penman. And these are my co-counsel.
Good morning, Your Honor.
Good morning.
My name is Leo Greenberg. I'll be conducting the cross-examination of Pat Nolan, the direct examination of Shawn Miller, and giving the closing statement for the defense.
Great. Good morning, Mr. Greenberg.
Good morning, Your Honor. My name is Mia Taubenblatt, and I will be conducting the cross-examination of Fran Ashcott and the direct examination of Ryan Williams.
Great. Good morning, Ms. Taubenblatt. And for, do one of you wish to introduce the witnesses, or the witnesses can introduce themselves?
Our witnesses can introduce themselves, Your Honor.
Good morning, Your Honor. My name is Devanshi Shah, and I will be portraying Shawn Miller today.
Good morning, Ms. Shah.
Good morning, Your Honor. My name is Lois Herring, and I will be portraying Ryan Williams.
Good morning, Ms. Herring.
Good morning. My name is Layla Shafizadeh, and I'll be portraying Nikki Penman today.
Great. Good morning to you as well, Ms. Shafizadeh. So I believe, as Ms. Francis mentioned, the attorneys who are presenting, whether it be delivering a jury address or conducting the examination, should remain on with their mic and their camera. If for a direct examination, for example, the attorney conducting the direct and the witness obviously should remain on camera. The attorney conducting cross-examination who would be objecting should remain on camera as well, but remain muted. Obviously unmute if there's an objection. In terms of objection, I would ask that initially briefly state the grounds for the objection. For example, hearsay, and then if there's additional argument, I will ask for that, and you could assume for that argument that it would be outside the presence of the jury. And let me ask from counsel for both the prosecution and the defense, do all the students have access to the documents from the case in front of them such that there's no need to show counsel documents prior to seeking to admit them?
Yes, Your Honor.
Yes, Your Honor.
And Francis went through the rules in terms of breakout rooms and time limits. I don't think we need to discuss them anymore. Are there any pretrial motions or applications from either party?
Yes, Your Honor. The people do have some preliminary applications before we begin.
Okay, you may go ahead.
Your Honor, since there is no bailiff present today, for judicial economy purposes, we ask that the parties stipulate that all witnesses have been sworn in.
Any objection to that?
No objections, Your Honor.
And lastly, Your Honor.
Yes.
And lastly, Your Honor, we ask that the witnesses be constructively sequestered from the courtroom, except for the defendant, Shawn Miller. But for educational purposes, we do understand that all witnesses must remain in the virtual courtroom at all times.
Ms. Bergner-Phillips, do you consent to that?
Yes, Your Honor, we have no objection.
Great. I will order the constructive witness sequestration of all witnesses other than the defendant. Is there anything further from the defense?
Yes, Your Honor, just one pretrial matter. It is our understanding, and we just want to be clear for all parties, that although there is no jury physically seated here today, today's trial would be a jury trial.
That is my understanding as well, correct.
Thank you, Your Honor. With that, we are ready to proceed.
Great. So I will turn it over then to the prosecution for opening statements.
Yes, Your Honor. May I proceed?
You may.
Defendant Shawn Miller is a seasoned hookworm with the charm to lure innocent investors into a false sense of trust. Sleight of hands, smoke and mirrors. The promise of infeasible double-digit returns was simply too eye-catching. Truly, the perfect bait. Shawn and Sydney agreed to become partners in their venture to make themselves rich. They partnered up to create their own firm, specifically aimed at duping investors with false assurances. The defendant's role in the conspiracy was critical to the success of the criminal enterprise, because without her alluring capability, her ability to connect and gain the trust of those she meets, the Ashcotts would not be victims, and they wouldn't have lost their life earnings. Miller may want this court to believe that she was collateral damage to the deception of her partner, Sydney Taylor. But Your Honor, don't fall for the wolf in sheep's clothing. This is a conspiracy and securities fraud case against one of the key defendants in a severed action. The evidence will show that the defendant, with her charm, baited innocent people and provided trusting investors with fake, monthly, double-digit returns. This was a phony investment scheme in which investors were paid by recently lured investors, giving it an appearance of legitimacy. However, paying investors with money from new investors is not profit. It's deception and it's fraud. The defendant and co-conspirator Sydney Taylor made off like bandits. The defendant, with her years of industry experience, is more than capable of defrauding innocent investors of their hard-earned savings. She would love to have you think that she worked her way up through the food chain of the New York stock market, using her years of industry experience to finally open up her own firm. If you pull back the curtain, however, all that remains is a true con artist, the defendant. Now, Your Honor, the people will call Fran Ashcott to the stand to explain how an innocent retiree was robbed of her life savings that she had cultivated with her husband over the course of their lives. Fran will explain how the defendant took the possibility of a secure retirement and flushed it down the drain. While Sydney's fake monthly statements brought their scheme halfway, it was Shawn's charm and collusion that brought the scheme to its completion. We will also call investigator Sharon Holmes to the stand to explain how Shawn's scheme was eventually uncovered because of her failure to pull the veil of ignorance over the Ashcott's eyes. The investigator will reveal the inner workings of a scheme that, well, easy to point fingers based on a paper trail, would not have been a scheme, Your Honor, without the convincing magician to distract their investors from that ultimate sleight of hand. Not only this, the investigator will reveal to the court exactly how their little financial trick worked, with testimony from the account executive and clearing agent who carried out orders from the defendant to falsify specific trades. In furtherance of unveiling this scheme, testimony from Pat Nolan, a longtime secretary, office manager, and insider to Shawn's scheme, will outline the very details of this plot. Pat was privy to the ins and outs of Shawn's involvement within SNS's criminal enterprise. Pat provides us with the smoking gun. We will prove beyond a reasonable doubt that on or about September 1st,
1 minute, please.
To on or about October 31st, 2019, that the defendant, acting alongside others, committed the crimes of conspiracy in the 5th degree and securities fraud by intentionally engaging in the fraudulent exchange of securities in excess of $250. Your Honor, the stage has been set. Just like it only takes 2 people to dance a tango, you only need 2 people, Your Honor, to hatch a Ponzi scheme. Thank you.
Thank you, Ms. Hernandez-Ramos. Defense opening?
Yes, Your Honor, permission to proceed?
You may.
May it please the court. Members of the jury, the prosecution just told you a tale of Shawn Miller's awareness of and engagement in securities fraud, but they will be unable to prove that their story is any more than just that, a story. As the prosecution presents their case, you will not hear testimony about Shawn handling fraudulent files. You will not hear anything about Shawn even being aware of fake files. You will not hear from any witness who can attest to speaking with Shawn about the fraud, and you will not hear any conversations in which Shawn herself spoke about the fraud. You will not hear any evidence proving Shawn Miller's involvement in the fraud at SNS Derivatives because Shawn had neither the skills nor the responsibility to carry out such fraud. Let me take a step back and introduce you to Shawn Miller. Shawn grew up in a working class family and dreamed of one day reaching financial freedom. Her childhood friend, Sydney Taylor, shared Shawn's dream throughout their friendship and into their professional relationship as the founders of SNS Derivatives. And yet, you will learn that Shawn's dream came crashing down at the hands of the person who was supposed to be her friend, Sydney Taylor, as he transformed SNS Derivatives into a Ponzi scheme. Now, there's no question that Sydney was running this Ponzi scheme at SNS, as he has already been convicted of that fraud. But in SNS Derivatives, there was a clear division of labor. You will learn that it was Sydney's job to make the firm's investments that turned out to be fake, and to write the firm's monthly statements that also turned out to be fraudulent. You will learn that it was Shawn's job to recruit new clients for the firm. This division of labor made sense considering the differences in financial skill and experience between Shawn and Sydney. You will learn that Sydney has a bachelor's degree from the Wharton School of Business and an MBA from Columbia University, while Shawn has an associate's degree from Far Rock College. You will learn that Sydney worked on a premier brokerage house on Wall Street, while Shawn began her career in the mailroom at Beeman Brothers. You will learn that after a few months, Shawn was promoted by Ryan Williams, the Beeman manager, to a junior associate position. This promotion happened because of Shawn's outgoing personality that made her suitable for sales. Shawn is a people person. You will learn that in order to carry out the fraud, Sydney Taylor worked closely with his own assistant, Pat Nolan, and with Bernie Madlock, a clearing agent at Stork and Manley who executed fraudulent trades for Sydney. You will learn that Pat Nolan helped Sydney deliver these fraudulent trading requests to and from Mr. Madlock. Ladies and gentlemen, the defense will call forth 3 witnesses today. First, you will hear from Shawn Miller herself. She will tell you about the division of labor at S&S, which left her totally in the dark regarding the fraud Sydney was carrying out. Next, you will hear from Nikki Penman, an auditor and accountant who worked on the external audit of S&S and will tell you about her thorough look into the firm's findings. Next, you will hear from Ryan Williams, Shawn's former manager, who will attest to Shawn's honest character, which she has exhibited throughout her entire career, starting back in her days in the Beeman Brothers mailroom. Ladies and gentlemen, you will also hear from the prosecution's witnesses today. Pay close attention not only to what these witnesses tell you, but also to what they cannot tell you. Throughout their testimony, you will not hear any witness tell you that they saw or that they heard Shawn carrying out fraud. The defense does not have a burden today. It is the prosecution that has the burden of proof. They must prove beyond a reasonable doubt that Shawn Miller helped plan or actually committed fraud at S&S. But the evidence presented today will leave you, ladies and gentlemen, with plenty of doubt.
1 minute,
throughout
please.
this case, you will not hear any evidence proving Shawn Miller was even aware of the fraud Sydney Taylor was carrying out, let alone engaged in it. At the end of this case, my co-counsel will remind you that Shawn had neither the skills nor the job description to have carried out this fraud. Shawn Miller's company was already destroyed by Sydney's actions. Don't let Shawn's life be similarly and unfairly destroyed. We thank you for your time, ladies and gentlemen, and we ask that you find Shawn Miller not guilty.
Thank you, Ms. Bergner-Phillips. The prosecution may call its first witness.
Yes, Your Honor. At this time, the people call Fran Ashcott to the stand.
And as we stated earlier, all the witnesses should assume that they've been sworn.
May I proceed?
You may.
Good morning, Mrs. Ashcott. Where do you currently reside?
I live in New Rochelle.
What's your current marital status?
I have a wonderful husband who is a retired chemical engineer. He's the love of my life.
What's your current employment status?
I'm currently retired after an amazing 35-year career.
Oh, when did you retire?
I retired back in June of 2015.
What was your occupation before retirement, though?
I was an English professor at Bartmore College.
While still working at Bartmore College, what, if any, steps did you take to ensure that you could one day retire?
My husband and I amassed a $3.5 million retirement nest egg over the course of our respective careers.
And who was managing your retirement nest egg when you retired?
Our money was managed by Beeman Brothers, specifically Shawn Miller, who was a junior associate.
What was your first impression of the defendant?
I first met Shawn back in April of 2016 when she was first assigned to my account. We honestly hit it off during our first meeting. Shawn had a very people-friendly demeanor, which made me trust her almost instantly.
Now, what was your first impression of the defendant as the associate assigned to your account?
She was initially fantastic. She managed my account over at Beeman's and provided me with consistent returns.
When was the next time that you met with the defendant?
The next time I met Shawn was December of 2016 to discuss my account.
What, if anything else, did you discuss during that time?
Shawn told me about a new company she was starting called S&S Derivatives.
To your knowledge, what type of company was S&S Derivatives?
Well, it was an investment company focused primarily on derivatives, hence the name.
So then what did you do with your investment account that you had at Beeman Brothers?
Well, my husband and I moved our money over with S&S.
What persuaded you to move your account over to S&S?
Shawn had done well for us for the past 8 months she managed my account. She was super friendly, easy to work with, and answered all of my calls. My husband and I trusted her enough to make the switch in March of 2017.
And how did your account perform at SNS from the time you first moved it over until 2019?
We were informed that we were earning 10% and in some months even 15% returns on our investment, even in months experiencing significant stock market downturns, which of course made us extremely happy.
Now, directing your attention to July of 2019, what did you do with your retirement account?
Well, I decided to act upon the advice of an investment blog, suggesting that I ask for more information about my account from my account manager.
What did you do after that?
Well, I contacted Shawn, who is my account manager.
For what reason did you contact the defendant?
I wanted to ask Shawn two very important questions that I had.
What were those two very important questions, Mrs. Ashcott?
First, I specifically requested information beyond my monthly account statements.
How did the defendant respond to that question?
Shawn specifically told me that my account was sound, assured me that it was fine.
Mrs. Ashcott, what was that second question that you had to ask the defendant?
I also wanted background information about the firm's investment strategies.
And how did the defendant respond to that question?
Shawn gave me the same assurances and also directed that I contact Sydney Taylor, who is Shawn's partner at SNS.
Mrs. Ashcott, how did these responses make you feel?
Well, based on my previous experiences with Shawn, I felt that she was being rather evasive.
So then what did you do after this conversation?
Well, honestly, I was confused as to why Shawn told me to contact Sydney, since I always thought that Shawn was the one in charge of my account. But regardless, I did what she said and tried to contact Sydney about 5 or 6 times over a 2-week period.
What happened when you tried to contact Sydney during that period?
Well, I never got past the assistant, Pat Nolan.
So then what, if any, action did you take after Sydney failed to return your calls?
I contacted the Securities and Exchange Commission to file a formal complaint, but because the investigation was stalled, I had to pursue other options.
What were these options, Mrs. Ashcott?
I contacted the Investor Protection Bureau at the New York Attorney General's office to file a formal complaint.
What happened after you filed the complaint?
I met with Sharon Holmes, who is the assigned investigator for my case.
What did you tell Investigator Holmes, Mrs. Ashcott?
My husband and I told Investigator Holmes about our suspicions with the account and the people managing it. We were primarily concerned about our initial investment.
What happened after that interview?
Well, my husband and I never found out anything else about the investigation until we learned that Shawn and Sydney had been indicted in February of 2020 for securities fraud. We were devastated.
Now, Mrs. Ashcott, what, if anything, did you receive from SNS regarding your investments?
A monthly statement of my account.
Your Honor, may the witness now look at what has been pre-marked as People's Exhibit 1 for identification purposes only. It's on page 105, and it's the monthly statement of accounts for the month of June.
You may.
Are you familiar with this document?
Yes, I am.
What does this document represent?
It is my June monthly statement.
Is this a fair and accurate representation of the monthly statement as you received it?
Yes.
How do you recognize this document, Mrs. Ashcott?
This document has my name on it as well as SNS derivatives.
How often did you receive this document?
Every single month.
What other information does this document contain?
It has all of my investment information on it.
Now, Mrs. Ashcott, did you receive this document within the regular course of business as an investor at SNS Derivatives?
Yes, I did.
Your Honor, at this time, we offer People's Exhibit 1 for identification purposes into evidence.
Is there an objection?
No, Your Honor.
Exhibit 1 is received. Thank you.
Now, Mrs. Ashcott, how much money did you believe was in your account as of June 30th, 2019?
Just over $3.5 million.
And based upon that monthly statement, how much did you believe that you had earned that month?
Over 10%, $365,739.84 to be exact.
Now, finally, Mrs. Ashcott, what happened to your $3.5 million retirement nest egg that you had invested with Shawn?
Shawn lost it all. My husband and I are now destitute and struggling to make ends meet.
Thank you, Your Honor. Thank you, Ms. Ashcott. No further questions.
Thank you. Their cross-examination?
Yes, Your Honor.
You may proceed.
Good morning, Ms. Ashcott.
Good morning.
So you just testified on your direct examination that Shawn was in charge of your account, correct?
Correct. He was the one I dealt with.
Right. I'd like to clear something up for the court. Sydney Taylor was in fact your financial advisor, correct?
Well, she was listed on my monthly statement, but I never even spoke with her.
So, Ms. Ashcott, on your direct examination, you testified that you received these client statements every month, correct?
Correct.
So every month you saw that Sydney Taylor was your financial advisor, correct?
Well, just on my June monthly statement. I don't recall about the other monthly statements.
I'd like to begin with the unfortunate consequences that the fraud at S&S Derivatives had for you.
Objection, Your Honor. Opposing counsel is testifying.
I'll allow low leeway here. I'll overrule it.
You invested all of your retirement savings with S&S, correct?
Correct, I did.
And as you testified, this totaled over $3 million, correct?
Correct.
And you and your husband have been forced to come out of retirement now, right?
Yes, it has been a struggle.
And you also lost your home, correct?
Correct, we had to move.
And you and your husband's lifestyle has been destroyed as a result of being cheated by S&S, correct?
Correct, it has been very difficult.
And you blame the executives at S&S Derivatives for losing everything you had, correct?
Well, of course, they were in charge of my money.
And you feel let down by Shawn?
Of course, I trusted him.
Angry at her?
Yes.
Let's talk about your introduction to S&S. You first met Shawn Miller in April of 2016 at VIII Brothers, correct?
Yes, I did.
She had just been assigned your retirement account, correct?
Yes.
And when you first met Shawn, you clicked with her and liked her instantly, right?
Yes, I did.
So at the time, you felt very comfortable working with Shawn, correct?
Correct, at the time I did.
And when Shawn was the manager of your account at VIII Brothers, you received consistent returns on your investment, right?
Correct, although modest in size.
But these returns were not the double-digit returns like S&S's were, correct?
No.
And at a meeting in December of 2016, Shawn first introduced you to her new company, S&S Derivatives, right?
Yes.
And you decided in March of 2017 to transfer your savings to S&S, correct?
That is correct, yes.
So at the time, you knew Shawn for 11 months, right?
Yes.
And based on that time, you fully trusted her management of your account.
Yes, she had done well for us.
You've known Shawn Miller for around 6 years now, correct?
Correct, just about.
And you still find it hard to believe that Shawn was in on the fraud?
Well, maybe I felt that way in the past, but I certainly don't feel that way now.
Ms. Ashcott, is it your testimony that you don't currently find it hard to believe that Shawn was in on the fraud?
As of now, I don't. Yes.
Ms. Ashcott, you wrote an affidavit for this case, correct?
Yes.
And you signed this affidavit, correct?
Correct.
And you would recognize this affidavit if I showed it to you, correct?
Yes, I would.
I would now like to direct your attention to your affidavit, Ms. Ashcott. Is this your affidavit, Ms. Ashcott?
Yes.
Is this a fair and accurate copy of your affidavit?
Yes, it is.
Is that your signature at the bottom, Ms. Ashcott?
Correct, it is.
I'd like to direct your attention to paragraph 14 of this affidavit. Please read along with me as I read aloud. It is difficult to believe that such a likable person as Shawn could have been involved in this despicable scheme. Ms. Ashcott, did I read that correctly?
Correct. Those were my words. Again, I wrote those over 2 years ago.
Okay. Thank you, Ms. Ashcott. So in February of 2020, 2 years ago, you learned that Sydney and Shawn were both indicted for securities fraud charges, correct?
Correct.
And you concluded yourself that Sydney was likely the driving force behind the scheme, correct?
Yes, I did feel that way.
But you believe Shawn must have known about Sydney's activity, correct?
Correct. They worked together so closely.
But you never spoke to Sydney Taylor, right?
Correct. She never returned any of my phone calls.
You never saw Shawn communicate with Sydney, right?
Objection, Your Honor. Speculation.
Overruled. You may answer the question.
Ms. Ashcott, yes, of course. You never saw Shawn Miller communicate with Sydney Taylor, is that correct?
I did not, but based on what Shawn told me, it was clear they were working closely.
You never visited the offices of S&S Derivatives, correct?
I don't believe I did, no.
Thank you, Ms. Ashcott. That will be all.
Ms. Hernandez-Ramos, is there a redirect?
Yes, Your Honor. Just a brief one. Mrs. Ashcott, do you know, when did you sign your affidavit?
November 9th, 2020, I believe.
That's about 2 years ago. Withdrawn. How long ago was that?
Just about 2 years ago.
And what is your sentiment about Shawn Miller today?
I definitely think that Shawn was involved. I mean, she lost all my money and now my husband and I are destitute.
Thank you, Your Honor. Thank you, Ms. Ashcott. No further questions.
And Ms. Tamalot, is there a recross?
Yes, there will be, Your Honor.
You may proceed.
Thank you. Ms. Ashcott, when you wrote your affidavit, you swore to tell the whole truth and nothing but the truth. Is that correct?
Correct, I did.
And it is your testimony that you no longer stand by the statements in this affidavit?
My opinions have changed. It has been over 2 years.
Thank you, Ms. Ashcott. That will be all.
Thank you. The prosecution may call its next witness.
Yes, Your Honor. The people call Sharon Holmes to the stand. May I proceed?
You may.
Good morning, Investigator Holmes.
Good morning.
Are you currently employed?
Yes.
Who do you work for?
The Attorney General's office?
What is your position at the Attorney General's office?
I am a senior investigator with the Investor Protection Bureau of the New York Attorney General's office.
Do you have any other roles within your position at the Attorney General's office?
I am also an analyst in that capacity.
How long have you been employed by the Attorney General's office?
Since 2010, so over 10 years now.
What are some of the responsibilities of your position?
To investigate and report illegal financial investment schemes to the Attorney General for prosecution under the New York Martin Webb Act, and to stay abreast of all the new and exotic securities in the market. Our charge is to protect the consumer.
Now, Investigator Holmes, prior to joining the Attorney General's office, what did you do for work?
I had worked 10 years in the security industry as a trader on the New York Stock Exchange for Goldman Sachs.
Your Honor, at this time, we respectfully request that Investigator Holmes be deemed an expert in the securities trading and analysis based upon her testimony here today, which has established her 10 years as a trader at the most prominent investment bank in the world, Goldman Sachs. And additionally, she has worked as a financial analyst at the Attorney General's office for over 12 years. In total, she has amassed over 20 years of professional experience in the securities industry.
Ms. Bergner-Phillips?
Yes, Your Honor. May I conduct a voir dire?
You may.
You last worked in securities trading over 10 years ago, correct?
That is correct, yes.
And you were fired from your job at Goldman Sachs, right?
Following a stock market crash, but yes.
After Goldman Sachs, you failed to find another job in the securities trading industry, correct?
I did.
Your Honor, We object to Ms. Holmes being qualified as an expert in securities trading, given opposing counsel has laid no foundation to any educational experience that she might have in this field. She last worked in the field of securities trading over a decade ago, and she was fired from this job and failed to find future employment. Thus, it would not be up to date enough on the current securities or have the requisite expertise to testify to this field.
And Ms. Geller, is there anything further you wish to say?
Yes, Your Honor. We still believe that Investigator Holmes does have the necessary requirements to testify as an expert here today. Although her job experience was a few years ago, she still does have over 20 years of professional experience in the securities industry, which does establish her expertise in this field.
I will qualify Investigator Holmes as an expert in the field of securities trading and analysis, given her specialized training and qualifications, and it's for the jury to determine how much weight to give her testimony. You may proceed.
Yes, Your Honor. So, Investigator Holmes, how did you get involved in this specific case?
On October 15th, 2019, my office was contacted by Mrs. Fran Ashcott. The Ashcotts had made a sizable investment with S&S Derivatives, LLC.
And what was the nature of this complaint that they had made?
The Ashcotts were concerned about their financial investment. They weren't receiving any return calls or given any information from S&S Derivatives themselves.
Objection, Your Honor. Hearsay. Question calls for hearsay as to the conversation with Ms. Fran Ashcott.
Ms. Geller?
Your Honor, may I be heard?
You may.
We just heard Mrs. Fran Ashcott testify to the contents of this conversation in court today.
Your Honor, may I be heard?
You may. Yeah.
Ms. Sharon Holmes is sequestered. She may not testify as to anything that we heard Ms. Ashcott speaking about.
And Ms. Geller, are there any other reason any of all of that testimony should come in aside from the prior testimony?
Yes, Your Honor. We believe this is highly relevant to establish the conspiracy in today's proceedings. The Ashcott's unreturned calls is the beginning of the conspiracy that we're here hearing testimony about today.
So I will allow the testimony to come in, but not for the truth of the statements being made, but to explain the subsequent actions that Investigator Holmes took. If Ms. Geller, you're looking for the actual truth of those statements from the Ashcotts to come in, there'll need to be more foundation for that admissibility.
Yes, of course, Your Honor. Thank you. So, Investigator Holmes, what was the nature of the complaint that the Ashcotts had made?
They were concerned about their financial investment. They weren't receiving any return calls or given any information from S&S Derivatives.
So what did you do next?
On October 17th, 2019, I met with Fran Ashcott in the Attorney General's office and then opened an investigation.
So as a result of this investigation, what, if anything, did you discover about S&S Derivatives?
Suspicious irregularities by the principals of S&S Derivatives.
Who are the principals of S&S Derivatives?
Shawn Miller and Sydney Taylor were equal owners.
What business were Sydney and Shawn involved in?
Investing consumers' money, like Fran Ashcott, into the derivatives market as well as the futures market.
And Investigator Holmes, where did they typically conduct this business?
Primarily in New York.
Now, can you please describe one of these suspicious irregularities you came across as part of your investigation?
S&S Derivatives refused to return client calls or give clients any information about their accounts. That was red flag number one.
Investigator, what else did you observe that was irregular at S&S Derivatives as part of your investigation?
S&S Derivatives was promising double-digit returns.
Objection, Your Honor. Objection, Your Honor, hearsay as to the out-of-court promise of S&S Derivatives.
Ms. Geller, go ahead. You may.
May I make a There is no statement being offered in this. Investigator Holmes is simply testifying to what she observed as part of her investigation.
Can you lay are you able to lay more foundation as to how she learned that?
Yes, Your Honor. She was conducting an investigation of S&S derivatives, and with this, she had to observe the what was going on at S&S derivatives during that time period, and this is what she observed as part of that investigation.
May I be heard, Your Honor?
You may.
Whether or not Ms. Holmes observed this in the course of her investigation does not negate the fact that opposing counsel is offering an out-of-court statement, being the promise for the truth of the facts and having the witness testify as to the suspicions regarding such statements.
Your Honor, may I be heard?
You may.
We are not offering these statements for the truth of the matter. We are simply offering them for just the fact that they occurred.
And anything further on that argument, Mr. Phillips?
Your Honor, offering them for the fact that they occurred relies on these statements being true.
Your Honor, may I be heard?
You may, briefly.
Again, Your Honor, there's no statements being offered. She is simply testifying to the events that occurred at S&S derivatives.
I'm going to sustain the objection as to the question and answer that was just given, as it seems to be offered for the truth, and would be, I think, any limiting instruction to the jury would not effectively cure any potential prejudice. So I will sustain the objection.
So, Investigator Holmes, what did you observe at S&S derivatives during the time of your investigation?
When on December 16th, 2019, I had the chance to visit S&S derivatives while Shawn Miller was present. I reviewed the books and uncovered the fishy returns.
1 minute, please.
The reported returns were too uniform over too long.
Your Honor. Once again, raising here's the objection as to the contents of the book.
Your Honor, may I be heard?
Yeah.
The books are not as part of our mock trial case here today. This is simply part of this witness's affidavit that she's testifying to, and she's not testifying to the contents of it rather than just referencing the existence of them.
So I'll allow, go ahead, Ms. Phillips.
Your Honor, the witness has testified to the returns that she observed in these books, which are explicitly the contents of these books. Whether or not she discussed these in her affidavit does not make it not an out-of-court statement.
Your Honor, may I be heard?
Let me just ask one follow-up to Ms. Phillips on that. As an expert witness, is she able to consider those materials?
Yes, Your Honor. As part of her expertise, it is part of her job to review these books and make conclusions and assessments about the books that she reviewed.
And Ms. Phillips, any view on that?
Your Honor, the witness may draw conclusions, but she may not explicitly reference the contents of these books, as they are an out-of-court statement and they have not been entered into evidence.
Your Honor, may I be heard?
I will allow. I don't think necessarily. I'll allow the testimony on that. But I would just ask you, well, two things. I saw time is up, given the objections, and do you allow additional leeway for a few more questions? But I would just ask you to establish that the witness reviewed these materials, and those are the types of a witness of her expertise would review. So I'll allow the questioning.
Yes, Your Honor. So, Investigator Holmes, did you finish your response to that question?
I can repeat it again if need be.
Yes, thank you.
When I visited S&S derivatives on December 16th, 2019, while Shawn Miller was present, I had the chance to review the books and uncover the fishy returns. The reported returns were too uniform over too long a period of time.
So, Investigator Holmes, what does this mean?
When the worldwide economy began to soften, the principals of S&S derivatives began to manipulate their books to make it appear to their investors that they were receiving the double-digit returns, as promised.
So, Investigator Holmes, based upon your expertise in this field, how do you believe that S&S derivatives manipulated the books?
As new clients were brought into S&S derivatives, the new money was credited to the accounts of existing clients to make it look like the older accounts had received the promised returns. The new money was simply moved among the different clients' accounts. And when a client wanted to cash out, they would receive the money requested, plus a confirmation of the sale in their account.
Investigator Holmes, what else did the SNS client receive during that time?
All SNS clients received 1099s showing the proceeds, dividends, as well as the interest earned. They also received monthly and annual statements with false confirmations of trade.
Now, Investigator Holmes, based on your expertise, how do you believe that SNS derivatives could possibly falsify confirmation of trades?
They needed someone at Storgan Manley to falsify the trades. Storgan Manley was responsible for executing most of the SNS derivative trades, and that is where Bernie Matlock became involved.
Investigator Holmes, who is Bernie Matlock?
Bernie Matlock was an account executive working for Storgan Manley, and he was directly responsible for executing all of the SNS derivative trades, as well as preparing the confirmation slips.
Now, Investigator Holmes, as part of your investigation, how did you come to discover Bernie Matlock's role at SNS, at Storgan Manley?
I interviewed Bernie for this case. Bernie admitted to the illegal trading scheme.
What exactly did Bernie admit to you, Investigator Holmes?
One, that he knew Shawn Miller since Beeman Brothers, and that it was Shawn Miller to introduce Bernie to Sidney Taylor. And two, that Sidney Taylor would deliver.
I'm sorry, I think may have broken up there. Ms. Berger-Phillips, were you about to say something?
Yes, Your Honor, I object to hearsay. Holmes was directly quoting from her interview with Mr. Matlock.
Your Honor, may I be heard on that?
You may, Ms. Geller.
This hearsay statement falls under Rule 402B as a co-conspirator admission. Bernie Matlock is an unindicted co-conspirator in this case, as stated in the indictment.
Your Honor, Rule 402 statement of a co-conspirator requires that furtherance of a conspiracy. These statements were made in with which certainly not the conspiracy, and still inadmissible.
So, Ms. Berger-Phillips, I heard most of what you said, but some of it broke out a bit. I don't know if it was just me or if anyone else had the same, but I understood your argument to be that 402B, I believe it is, requires the statement to be in furtherance of the conspiracy. So, Ms. Geller, why would the statement in furtherance of the conspiracy?
Your Honor, we believe that conspiracy has already been established through the testimony of Fran Ashcott and through the testimony that we heard already of Investigator Sharon Holmes. What Bernie Matlock admitted to Investigator Holmes is exactly in furtherance of the conspiracy. The defense has withdrawn. Bernie Matlock is listed as an unindicted co-conspirator in this case, which does mean that he had a role to play in the furtherance of the conspiracy.
So I agree with most of what you said there. Can you explain why, though, the statement furthered the conspiracy?
Yes, Your Honor. Well, Investigator Holmes did not finish her response, but in her response, it does say how it furthered the conspiracy.
Your Honor, I'd just like to draw attention back to the wording of the rule, which states that by a co-conspirator of a party must be made during the conspiracy. This interview occurred. Your Honor, can you see?
We are having a little difficulty. Your opening came in perfectly. There were no issues at all during opening. So this is the first time you're breaking out a bit. I don't know if you want to try logging back in. That might help.
Can you hear me now?
Yes. Yeah.
I think it might be better now.
Oh, wait, I can't hear.
Okay.
I'm sorry. Okay. Can you hear me now?
Now it's much better.
Thank you so much. I sincerely apologize for the difficulties. I was just referring to the specific wording of the rule, which states that statements of a co-conspirator must be made during the course of and in furtherance of the conspiracy. This statement was made during an interview with Ms. Holmes, which was after the completion of the conspiracy, and it was certainly not in furtherance, as Mr. Matlock was speaking with an investigator, not acting in the conspiracy.
Your Honor,
I'm going to sustain the objection. I don't think it falls within the co-conspirator exception. So The objection sustained, and I'll instruct the jury to disregard the answer.
Your Honor, may I just be heard one moment briefly about the ruling about the co-conspirator statement?
You may.
I respectfully request that you reconsider your ruling and take a moment to review Rothschild Rule 402B, as this rule does allow all co-conspirator statements, and this statement is critical to the prosecution's case. This rule was specifically designed for the very purpose that these statements be included in today's proceedings.
So the issue, though, is the requirement in the rule that it be in furtherance of the conspiracy, that the statement that was made here, the statement made by the witness, by Madlock to the witness, was made by Madlock in furtherance of the conspiracy. So that's the basis for the ruling.
Your Honor, we do believe that this is in furtherance of the conspiracy, as the statements made by Bernie Madlock are in furtherance of the conspiracy, as he did testify, or as he did say to Investigator Holmes, he testified to the false trading documents that were being used at SNS Derivatives, which is exactly in furtherance of the conspiracy.
And Ms. Bergner-Phillips, anything further?
Your Honor, this co-conspirator rule, the in furtherance of a conspiracy, requires that the conversation be in furtherance of a conspiracy. The fact that Mr. Madlock was testifying to the elements of the conspiracy in the past does not mean the conversation was in furtherance.
I agree. I'm going to keep my ruling to sustain the objection, and you may move on, Ms. Geller.
I have no questions anyway, Your Honor.
Okay. Cross-examination, Ms. Berger-Phillips?
Yes, Your Honor, and just in advance, do please let me know if there's any difficulties with my audio. May I proceed? Let's begin by talking about your career background. So you're currently an investigator at the New York Attorney General's office, correct?
I am, yes.
And before this job, you worked in the securities trading industry yourself, right?
I did.
As a trader at Goldman Sachs for 10 years?
Yes, as stated before.
So you were fired from this job following the 2008 stock market crash, correct?
Yes, unfortunately.
Is it fair to say that today you're still upset about the loss of that job?
Objection, Your Honor. Relevance.
Your Honor, may I be heard?
You may.
If I may proffer, this question this line of question will go directly to a point of bias that the witness has against the defendant, and bias is always relevant.
Ms. Geller, wouldn't this be fair grounds for bias?
Yes, Your Honor.
I'll allow it overall.
I'll re-ask the question. Is it fair to say that today you're still upset about the loss of this job?
Sure, I spent 10 years there. Who wouldn't be?
And you believe you lost your job as a result of greedy executives, correct?
I did make that statement, yes.
You specifically believe that people like Shawn Miller, the defendant in today's case, cost you your Wall Street job, correct?
Yes, that is a statement I made.
So despite holding this belief, you agreed to lead the investigation into Shawn?
I did.
Let's shift gears now to talk about that investigation. So as you testified, Bernie Madlock was a clearing agent at Storg & Manley, right?
Yes.
And in this position, he executed fraudulent trades for SNS, correct?
Yes, that was what he admitted to me.
So you believe that Shawn Miller was aware of Bernie's involvement in the fraud at SNS, correct?
Yes.
You interviewed Bernie on December 2nd, 2019?
I did.
And you found his answers during this interview to be credible, right?
Yes, of course.
Because as you testified on direct, he actually admitted to his illegal scheme, correct?
Objection, Your Honor. This testimony was not admitted as part of the hearsay exception.
Your Honor, if I may, this testimony was actually in the prior question of the witness. It was in the prior answer, not the question that I objected to. It was not strict to the record.
I'll allow the question overruled. The witness may answer.
As you testified on direct, Mr. Madlock actually admitted to his illegal fraud, correct?
Yes.
To be clear, Mr. Madlock did not say that he worked with Shawn on SNS during your interview, correct?
Conveniently not.
Well, in fact, you didn't ask Mr. Madlock if Shawn was involved in the fraudulent trading, correct?
Not directly, but Shawn was never explicitly mentioned either.
So you believe that the fraud at SNS was conducted through a flash drive exchange, right?
Yes.
And these flash drives were where the actual fraudulent trades were stored, correct?
Yes.
So Pat Nolan delivered these flash drives with illegal trading requests to Mr. Madlock?
Yes, as well as Sydney Taylor.
Right, so to your knowledge, Sydney Taylor was involved in working with these flash drives?
To my knowledge, yes.
But you never found any evidence of Shawn delivering these flash drives, correct?
Again, conveniently not.
You actually never looked into these flash drives at any point yourself during your investigation, correct?
Objection, Your Honor, calls for invention of facts.
Your Honor, may I be heard?
You may.
According to mock trial rule 702, invention of fact, the witness may answer a question in any way that does not materially impact the outcome of the case. And this rule does not allow for objection by opposing counsel. Ms. Holmes has already testified to the flash drives and has spoken about them in her affidavit.
I'll allow the question and answer subject to the limits of the mock trial rules.
I'll re-ask the question. Ms. Holmes, you didn't actually look into these flash drives yourself during your investigation, correct?
No, I did not.
So I want to now talk a bit about the timeline of the fraud. It is your theory that S&S Derivatives was conducting real trades for the first year or so, correct?
Yes, it is my theory.
And you believe that the fraud began in the middle of 2018?
Yes,
This was after Sydney Taylor began running the firm, correct?
that is true.
So you would agree with me that you did not uncover any evidence of fraud from before Sydney joined the company?
From before Sydney joined the company?
Yes.
No, I didn't, no.
So I want to take a look now at some of the other interviews you conducted during your investigation. So you testified on direct that S&S regularly refused client calls, correct?
Yes, I did.
And that this was one of the red flags in your investigation?
It was.
To be clear, Ms. Holmes, you only spoke to one client from S&S during the course of your investigation, correct?
Fran Ashcott, you mean? Yes.
Yes. One of the additional pieces of evidence you relied on to conclude that Shawn knew about Bernie's fraud was your interview with Pat Nolan, correct?
Yes.
During your interview with Pat, she recalled a conversation that she had overheard, right?
She did, yes.
This alleged overheard conversation took place over a year before your interview with Pat, right?
It did.
To clarify, Pat Nolan was Sydney Taylor's executive assistant, correct?
Yes, that was what Pat Nolan's job was at the time.
Is it correct that you did not interview Shawn's assistant?
I did not.
Objection, Your Honor, again, calls for invention of facts. This materially alters this witness's testimony here today, therefore it is not admissible under this rule.
Your Honor, I'd like to rephrase my responses before. The mock trial rules do not allow opposing counsel to object. Given the fact that Shawn's assistant is mentioned in the fact pattern of this case, and Ms. Holmes wrote an affidavit in which she swore to tell the whole truth and nothing but the truth and did not mention interviewing Shawn's assistant, one can extrapolate from that she did not, in fact, conduct such an interview.
I will allow the question. The Rule 702 does say on cross-examination that cross-examination should not seek to elicit information that is not contained in the fact pattern, although if that does occur, as noted, the witness may respond with an answer that does not materially alter the outcome of the trial. So I will allow it subject to that rule.
It is correct that you did not interview Shawn's assistant, right?
I did not feel the need to, no.
So to be clear, you only felt the need to interview Sydney Taylor's assistant during the course of your investigation?
Yes, and that's what I did.
You also never interviewed Sydney Taylor, the other executive at S&S, correct?
No, I didn't get the chance to.
Ms. Holmes, is it your testimony that you repeatedly tried to interview Mr. Taylor and failed?
Yes, when I went to S&S Derivatives, I wanted to speak to Sydney Taylor. Sydney Taylor was not present.
To be clear, after that initial visit to S&S, you did not attempt to interview Sydney at any further point, correct?
No, I did not.
And Sydney Taylor has now fled the country, correct?
Yes.
So I want to now move to talk about the firm's books that you discussed on direct examination. You believe that at first glance at these books, you could tell that there was fraud, correct?
Yes.
And thus you believe that Shawn should have been able to see the fraud, correct?
Yes, I mean, Shawn was running the company for 8 months by herself.
But before you saw the books, you had been investigating Shawn for several months, correct?
Yes.
And you had already interviewed Bernie Madlock, correct?
Yes, on December 2nd, and I visited SNS at December 16th.
So to be clear, you already knew that the statements were fake, correct?
Statements, meaning what statements?
The documents contained within the firm's books.
Yes, my investigation believed me to lead that they were fake.
Thank you, Your Honor. No further questions.
Redirect, Your Honor.
You may, Ms. Geller.
So, Investigator Holmes, why didn't you review the flash drives at SNS Derivatives?
I didn't feel the need to. My investigation already had testimony enough I felt I could convict and bring to the Attorney General.
And Investigator Holmes, why couldn't you interview Sydney Taylor when you went to visit SNS Derivatives?
Sydney Taylor was not present, just like Sydney Taylor refused to answer return calls for Fran Ashcott and many other clients.
Thank you, Investigator Holmes. Nothing further.
Any recross?
Yes, Your Honor. You just testified to that you believe that you had sufficient evidence on the flash drives from your interview. Is it your testimony that the statements of Mr. Madlock were sufficient for you to conclude your investigation into a crucial aspect of the fraud, correct?
Yes, Bernie admitted to an illegal trading scheme.
And in regards to Sydney Taylor, I just want to clarify something. You did not attempt to interview Mr. Taylor past the one initial visit to the firm, correct?
No, I didn't.
Thank you, Your Honor. No further questions.
Thank you. The witness may step down. Thank you, Investigator Holmes. And the prosecution may call its next witness.
Yes, Your Honor, the people call Pat Nolan to the stand. May I proceed?
You may.
Good morning, Miss Nolan. Can you please inform the court of your educational background?
Yes, I attended 1 year at the John Jay School of Business where I studied to be an administrative assistant.
Did you receive any certificates as a result of this schooling?
Yes, I received my business school certificate in May of 2013.
Now, after you finished schooling, what, if anything, did you do next?
I got a job as an administrative assistant at Terrell Hinch, Fierce Fenner & Smith, which is a large investment firm on Wall Street.
How long were you at Terrell Hinch for?
For about 4 years.
And who was your boss at Terrell Hinch?
I was the administrative assistant under Sydney Taylor.
What, if any, experience did you gain from working under Sydney Taylor?
Well, Sydney taught me a lot about client investment scenarios and opportunities, investment scenarios, Wall Street, and just investments in general.
Now, after working at Terrell Hinch, where, if anywhere, did you work next?
I got a job as the office manager and executive assistant to Sydney Taylor at SNS Derivatives, so I had dual roles.
What did your 2 new positions at SNS Derivatives entail?
Well, I did all the normal duties of an office manager and an executive assistant, and I continued to help Sydney fill out the monthly client statements.
Now, as the SNS Derivatives office manager and Sydney's executive assistant, what exactly were you being paid for these 2 roles?
I was making a 6-figure salary, which is standard for someone taking on both of those roles.
Was there any incentive-based pay at SNS Derivatives?
Yes, I was actually making up to $20,000 bonuses annually. Since SNS was making so much money, they allowed me to make more money as well.
Now, Miss Nolan, are you familiar with Shawn Miller?
I am.
What was Shawn's role at SNS Derivatives?
Shawn was co-partner and co-founder of SNS along with Sydney Taylor.
In what capacity did you work with the defendant, Shawn Miller?
Well, Shawn, Sydney, and I would often meet to fill out the monthly client statements.
How often would Shawn and Sydney work together?
Oh, well, they were always getting together to review company matter, and on at least one day each month, they would get together to review the client accounts.
Who would handle the trade requests for these client accounts?
Bernie Madlock over at Storg & Manley would handle the trade requests.
Who would send the trade requests to Bernie Madlock at Storg & Manley?
We would, Shawn, Sydney, and I.
How did Bernie Madlock receive these trading requests?
Well, on occasion, under Sydney's instruction, I would hand deliver the flash drives, or I would hand deliver the trade requests via flash drive to Storg & Manley, but never by regular mail or email.
For what reason were the trading requests delivered by flash drive only?
I didn't know at the time, but I do now.
Now, let me direct your attention to early July of 2018. What, if anything, happened of significance at that time?
Objection, Your Honor. Counsel is leading the witness.
Overruled. You may answer.
Shawn, Sydney, and I were working on the June monthly client statements when I overheard an interesting conversation between Shawn and Sydney.
What did you hear between Shawn and Sydney?
Objection, Your Honor. The question calls for hearsay.
Your Honor, may I be heard?
You may.
Your Honor, this testimony is admissible under Mock Trial Rule 402B. It is a co-conspirator statement in furtherance of the conspiracy.
May I be heard, Your Honor?
You may, Mr. Greenberg.
Your Honor, the specific statements that we expect Ms. Nolan to testify to are vague in nature, and there's been little to no foundation laid to suggest that they were actually in furtherance of a conspiracy. It's not sufficient to establish that they were made during the duration of the conspiracy. The specific statements have to be in furtherance of said conspiracy, and it's our belief that these statements are too vague to meet that standard.
Your Honor, may I be heard?
You may. Go ahead.
Your Honor, we contend that this does establish and prove a conspiracy, as Ms. Nolan witnessed this conversation between Shawn and Sydney at SNS Derivatives. She was present as the fraud was occurring, so therefore it does fall under Mock Trial Rule 402B.
May I be heard, Your Honor?
Very briefly, we need to move on with the testimony.
Yes, Your Honor. Ms. Nolan's presence is not sufficient to establish that these statements were in furtherance of any conspiracy.
So I will overrule the objection to the extent that I want to hear what the answer will be. If the statement is, I don't think, is in furtherance of the conspiracy, then I'll instruct the jury not to consider the answer, but I'll allow the witness to answer the question.
So what did you hear Shawn and Sydney say?
Well, I heard Sydney say to Shawn, "Did you ever think this could be so easy? If only they knew." To which Shawn replied, "Way too easy, I say. He's doing a great job for us."
Now, Ms. Nolan,
Objection. I'd like to re-raise my objection to hearsay.
I will overrule the objection and allow the statement. You may cross-examine the witness on that statement, but I'll allow it.
Now, who did you believe they were talking about, Ms. Nolan?
Well, in retrospect, based off of what I heard and my personal beliefs, I think that they were talking about the securities fraud going on at SNS right under my nose.
Objection, speculation, Your Honor.
Mr. Mason, you may.
Your Honor, this falls under Mock Trial Rule 501. It is opinion testimony by a non-expert. Ms. Nolan is allowed to give her opinion on what she saw or heard at SNS Derivatives. She witnessed the fraud occurring. She was there with Shawn and Sydney. Therefore, she can make this conclusion based on what she saw.
Your Honor, may I be heard?
You may.
Your Honor, Rule 501 makes clear that a witness may not testify to any matter for which the witness has no personal knowledge. The witness was merely overhearing a conversation and does not have personal knowledge as to the greater context of this conversation. The statements which have been admitted can speak for themselves, but bringing in Ms. Nolan's personal conclusions or guesses about this conversation is surely speculative.
I will sustain the objection. I don't think a foundation has been laid that she has personal knowledge as to who the he was that was referenced. So the statement is in, but her opinion as to what was meant by the statement is not allowed. So I'll instruct the jury not to consider that testimony. You may continue.
Now, Ms. Nolan, what, if anything, did you ask Sydney in regards to this conversation?
Well, of course I asked Sydney about the conversation, and she said that they were just talking about the Yankees and how well they were doing that season.
And Ms. Nolan, once again, what were you, Shawn, and Sydney all doing at the time?
We were solely filling out the monthly client statements. It was not relevant to the Yankees whatsoever, and not once did anyone ever mention the Yankees.
Moving on, are you aware of a second set of books at SNS Derivatives?
Absolutely not. To my knowledge, there is only one set of books, regardless of what anybody speculates.
And lastly, Ms. Nolan, why are you here today?
I volunteered to testify here today because all I want is for the truth to come out.
Thank you, Ms. Nolan. Thank you, Your Honor. Nothing further.
Thanks. Mr. Greenberg, cross-examination.
Yes, Your Honor. Permission to proceed. So,
You
Ms.
may.
Nolan, I'd like to talk about your role in today's case. You're here as an unindicted co-conspirator in the alleged crimes of Shawn Miller and Sydney Taylor. Is that right?
Correct, unindicted.
Now, you believe if convicted of the crimes listed out in the indictment, you might have gone to jail, right?
Well, I'm unindicted, but yes, possibly.
Instead, though, you're here to help the government by testifying against Shawn Miller, correct?
I believe I have very vital evidence to, yes, convict Shawn Miller.
So that's a yes to my question.
Yes.
Let's take a step back. As you testified on direct, you first met Sydney Taylor in 2013 when he hired you to work for him at Terrell Hinch, right?
I did, yes.
Sydney hired you as his administrative assistant, correct?
He did.
And you felt that Sydney took a special interest in you, correct?
Yes, he was like a mentor.
He gave you responsibilities that were more advanced than was typical for other assistants, right?
Well, filling out the monthly statements was really the only responsibility beyond that of my role, but yes.
But to be clear, this was more than was typical for other assistants, correct?
Objection asked and answered.
Overruled, she may answer.
Was that a yes, Ms. Nolan?
Yes, it was.
In 2016, Mr. Taylor told you that he was planning to leave Terrell Hinch to create his own firm, right?
He did, yes.
He promised you a good job at this new firm, S&S Derivatives, right?
Objection, hearsay.
May I be heard, Your Honor?
You may.
Your Honor, we're not offering this for the truth of the matter, but rather for the effect on the listener, Ms. Nolan, as this played a role in leading her to her work and her new job at S&S.
I'll overrule the objection and allow the testimony not being offered for the truth, but for the impact on the witness.
I can repeat my question, Ms. Nolan. Sydney promised you a good job at this new firm, S&S Derivatives, right?
Yes, he did.
And in October 2017, as you testified, you joined S&S Derivatives as office manager and executive assistant, right?
Correct.
Now, your only problem working at S&S was actually your relationship with Shawn, right?
Objection, argumentative.
Your Honor, I'm simply asking the witness about her work experience at S&S.
Your Honor.
I'll allow it. Go ahead, Mr. Macon.
Opposing counsel is referencing her problem with Shawn Miller. If they would like to rephrase, that would be good, but it is argumentative as she's talking about, they're assuming that she had a problem with Shawn Miller.
Mr. Greenberg, would you be able to rephrase that and not have the word problem?
Sure, Your Honor. Ms. Nolan, you believe that Shawn didn't want to hire you to work at S&S, right?
Correct, but it never became a real issue.
And you held this belief because Shawn's assistant told you that, right?
Yes.
You also think that Shawn wanted to stop you from getting a $20,000 bonus, correct?
Yes, but not enough to actually stop them.
But to be clear, you believe that Shawn wanted to stop you from getting $20,000, right?
Objection asked and answered.
Your Honor, I'm just asking the witness to clarify.
Yes, it was my belief.
So, Ms. Nolan, I want to talk a little more in depth about some of your responsibilities at S&S. You continued filling out monthly statements for Mr. Taylor, correct?
I did.
You were also tasked, as you testified, with sending trading requests to Mr. Madlock, a trader at Storgan Manley, correct?
Under Sydney's instruction, yes, I was.
And you never sent these requests by email, right?
No.
You never sent them through the regular mail, right?
Nope.
Instead, each time you delivered the request on a flash drive to Mr. Madlock, correct?
I did, whenever Sydney would tell me to.
Right, it was always Sydney who gave you the instruction to deliver the flash drives, right?
Correct, but Shawn was a part of it.
But to be clear, Ms. Nolan, Shawn would never deliver these flash drives, correct?
Correct.
And Shawn would never instruct you to deliver these flash drives, correct?
Well, being that I was Sydney's assistant, yes, Sydney would ask me to.
So to be clear, Shawn never instructed you to deliver the flash drives, right?
Correct.
Another responsibility of yours was to take calls from your clients, right?
Yes.
In 2019, a client named Fran Ashcott called hoping to speak with Mr. Taylor, correct?
Objection beyond the scope of direct examination.
May I be heard, Your Honor?
You may.
Your Honor, if you'll give me some leeway here, this line of questioning goes to Ms. Nolan's credibility, as it will be used to demonstrate a bias towards her boss, Mr. Taylor, and against Shawn Miller.
Your Honor, may I be heard?
I'll allow Lil. You may go ahead.
Your Honor, regardless of if it goes to this witness's credibility, it did not come out on direct examination. This testimony is also hearsay as it is referencing a call from Fran Ashcott, which would not fall under any of the mock trial hearsay exceptions.
May I be heard,
Do you
Your
want
Honor?
to address the hearsay point? Yeah.
Yes, Your Honor. As to the hearsay objection, I'm not eliciting any specific statement on the part of Ms. Ashcott, just the fact that she called us. There's no out-of-court statement. There's no truth value to anything in that information.
I'll allow the question based on the proffer that was just made, and if there is hearsay that's elicited, Ms. Macon can renew his objection.
So I can repeat my question, Ms. Nolan. Ms. Ashcott called you in 2019 hoping to speak with your boss, Mr. Taylor, right?
He did.
She called you 5 or 6 times, right?
Yep, over a 2-week period.
And Mr. Taylor instructed you that he was not available to speak with Ms. Ashcott, right?
That's correct, and that's what I told her.
So I'd like to now discuss the conversation that you mentioned on direct examination. In this conversation, you said that you remembered your boss, Mr. Taylor, saying something like, "Did you ever think it could be so easy if only they knew," right?
Yes, that happened.
And then Shawn said, "Way too easy." I say, "He's doing a great job for us," correct?
Correct.
Now, in this conversation that you overheard, you never heard a reference to the work of S&S Derivatives, right?
Not explicitly, no.
You never heard a reference to investing or broader financial terms, right?
Technically, no, but there were no baseball terms involved either, so.
But back to my question, you didn't hear anything about finance or investing, correct, Ms. Nolan?
Not explicitly.
And you never heard the name Bernie Madlock mentioned, right?
Again, not explicitly, no.
So when you asked Mr. Taylor about this conversation, he told you that it was about the New York Yankees, as you testified, right?
He did.
And Ms. Nolan, you believed his explanation, right?
At that time, I did.
Well, to be clear, Ms. Nolan, you believed this explanation for over a year after Mr. Taylor gave it to you, correct?
Sure, because I trusted Sydney, and it took a while and for the indictment to come out. Of course, I believed it at the time.
And Ms. Nolan, you never had a second conversation with Mr. Taylor where you asked him about this conversation, correct?
Objection and calls for invention of facts.
Your Honor, as we've previously discussed on Rule 702, the witness is free to answer the question so long as it does not materially alter the outcome of the case.
Your Honor, may I be heard?
You may.
Either way this witness answers this question, it still has immense value on the outcome of the case, as it is a possible admission of guilt from Sydney Taylor herself.
Your Honor, if the answer given was to describe an admission of guilt for Mr. Taylor, then that would alter the outcome of the case. But so long as the answer doesn't include that, it's perfectly permissible under Rule 702.
And could you just repeat the question again?
The question was, you never had a second conversation with Mr. Taylor about the conversation, correct?
I'll allow that. I'll allow that question pursuant to the limits of 702.
1 minute left, please.
So Ms. Nolan, you never had a second conversation with Mr. Taylor, correct?
No, I didn't feel the need to.
So finally, I want to talk about how you came to your conclusions in this case. You must have thought about before testifying that you believed or that Mr. Taylor refused to take any of Fran Ashcott's calls, right?
Sure, I'm sure he was busy.
You must have thought about that Mr. Taylor instructed you to deliver flash drives to Mr. Madlock, right?
Yes, he instructed me to do so.
And I'm sure you recognize that Mr. Taylor generally took the lead on investment decisions at S&S, right?
Generally, but Shawn and Sydney were the key principals of S&S, so Shawn had much involvement and they were always keeping each other updated on company matters.
And based on all this information about what Mr. Taylor did, you concluded that he did nothing wrong, correct?
Not necessarily, no. I think that Shawn and Sydney both had something to do with it, and justice deserves to be served.
Ms. Nolan, is it your testimony that you do not believe that Mr. Taylor did nothing wrong?
I think that Shawn should not be used as a scapegoat, but that doesn't necessarily mean that Sydney did nothing wrong.
Time is up.
Ms. Nolan, I want to be very clear. May I have a little leeway on the time, Your Honor, just to finish this line of questioning?
You may.
Ms. Nolan, is it or is it not your testimony that Sydney Taylor did not or did something wrong at S&S Derivatives?
Sydney Taylor was convicted after trial as guilty.
Ms. Nolan, that's not an answer to my, or Ms. Nolan, you wrote an affidavit for this case, correct?
Correct.
You swore to tell the whole truth. You swore to tell the truth, the whole truth, and nothing but the truth, correct?
I did.
You signed this affidavit, is that right?
Of course, yes.
Ms. Nolan, I'd like to direct you to your affidavit, which is on page, give me 1 second here, page 75 of the case packet. Is that, yeah. Do you have the affidavit up, Ms. Nolan?
I do.
And that's your signature at the bottom, correct?
Yes.
And this is a fair and accurate copy, right?
It is.
And please read along silently as I read aloud in paragraph 9. I think that Shawn Miller should pay for their crimes and that my boss shouldn't be the scapegoat for any hanky-panky. I wish Sydney's attorneys had called me to testify at Sydney's trial. Did I read that correctly, Ms. Nolan?
You did, and I believe I answered that.
Thank you very much, Ms. Nolan. No further questions.
Is there a redirect?
Yes, Your Honor. Excuse me, sorry. Miss Nolan, once again, why are you here today?
I believe I have valuable information to this case, and I would like the truth to come out.
And do you disagree with the conviction of Sydney Taylor?
No, I don't disagree with it.
Thank you, Your Honor. No further questions.
Any recross?
No recross, Your Honor.
Okay, thank you. The witness may step down. Does the prosecution have any further witnesses?
At this time, the people rest, Your Honor.
Okay. Would the parties like to take a 5-minute break before the defense case?
That's all right with us, Your Honor.
Okay. So why don't we take a break for about 5 minutes, and we'll resume at a little bit after 10:25, around 10:26 or so.
Thank you, Your Honor.
Great, thank you.
Okay, at this time, only the attorneys may go back into your breakout rooms if you choose to.
They want you to have some other path for yourself. Not a good kind of achievement. I think they both want it.
The defense is ready to proceed, Your Honor, if all parties are here.
The people are also ready to proceed, Your Honor. All parties are here.
Your Honor, I believe you're on mute.
Thank you. I was unmuted on my phone, but not on the computer, so that did it. So Mr. Greenberg, the defense may call his first witness.
Your Honor, the defense calls Ms. Shawn Miller to the stand.
You may proceed whenever you're ready.
Thank you, Your Honor. Good afternoon, Shawn.
Good morning, I think.
Good morning. My
Good morning.
apologies.
Good.
Can you please state your full name for the court?
My name is Shawn Miller.
Shawn, how did you first meet Sydney Taylor?
I first met Sydney Taylor in elementary school. We went to the same middle schools and stayed close over the years.
And Shawn, how did you first get interested in business?
Growing up, my family didn't have a lot of money, and I always dreamed about being able to provide for them. I read a lot of books in high school about people who came from nothing and worked their way up and were able to help their families out. And so those kinds of stories had a big effect on me.
After high school, did you go to college?
I did go to college. I went to Far Rockaway Community College to get my associate's degree in business administration.
What, if anything, did you do after graduating?
Well, my parents wanted me to go to NYU, maybe get a bachelor's degree, but I knew by then that school just wasn't for me. I started looking for work instead, and I found a job working in the mailroom at Beeman Brothers, which is a large Wall Street firm. Made some connections, and with the help of some people like Ryan Williams, I worked my way up to junior associate.
Who is Ryan Williams?
Ryan Williams was my friend and also my mentor at Beeman Brothers. She was really invested, no pun intended, in helping out other women on Wall Street.
What was your relationship with Ryan like?
Objection, Your Honor, calls for narration.
Your Honor, Ms. Williams is here to testify today, having a basic understanding of her relationship with Shawn is important context, and the witness can keep her answer limited to important information about the nature of their relationship.
So I'll overrule the objection, but I'll ask that the witness not provide an answer that turns into a narrative.
So Shawn, what was your relationship with Ryan like?
It was good. We'd frequently have lunch together, talk about hot stocks, current events. She was a cool person to talk to.
Now, you mentioned earlier that after working in the mailroom, you became a junior associate. What did you do as an associate?
As an associate, I was mostly working with the stocks as a stock salesperson. So I would sit down with clients and talk to them about their goals, where they wanted to be in 10 years. And based on that, I would put together a stock portfolio to help them achieve those goals. The only problem was I didn't have too much experience on the more technical side of investing. So I decided to study for a few FINRA exams.
And can you explain for the jury what a FINRA exam is?
Objection, Your Honor, calls for narration. This answer could go on and on about what a FINRA examination is. If opposing counsel wants to limit the question or change the question's wording, that would be preferred.
I'll sustain it. Mr. Greenberg, why don't you rephrase that question?
Sure. Shawn, what were the FINRA exams you took? What would they allow you to do?
I took 2 FINRA exams. I took the Series 6 exam on mutual funds and variable annuities, and the Series 7 exam to be licensed as a stockbroker. If you pass the FINRA exams, you're licensed to take out more sophisticated financial decisions.
And did you prepare for the FINRA exams with Mr. Taylor?
Oh, gosh, no. Sydney was studying for super complicated exams. He was learning how to manage his own investment company. He was learning how to trade really fancy securities and derivatives. I was just studying for the basic ones.
As for the 2 exams that you took, Shawn, did you pass those exams?
It took a few tries, but eventually, yes, I did.
Shawn, are you still working at Beeman Brothers?
No, I'm not.
Why did you leave Beeman?
In July of 2016, Sydney approached me about the possibility of starting our own firm together, and I said I was interested.
Why were you interested in working with Sydney?
Well, firstly, I had known Sydney for such a long time, and I thought that we could work pretty well together. And secondly, I knew that Sydney was super experienced. I mean, went to the best colleges and universities in the country, was trained by some of the best firms in the country. I thought he would be a good person to work with.
Shawn, how was the shift from working at Beeman Brothers to this new firm?
It was stressful at first, especially because Sydney wasn't around much in the beginning. I was doing pretty much everything on my own.
Why wasn't Sydney around much?
Well, Sydney had a do not compete clause with her own firm, so she couldn't directly work with us, but he did direct me to what kinds of trades to make and when.
And how did things change when Sydney joined the company?
Things definitely got a lot easier. We divided up our tasks. At that point, I was only working with clients and client relations, and Sydney handled all the technical aspects of investing.
Shawn, was S&S Derivatives a successful venture?
For a while, yeah, it seemed like everything was going pretty smoothly up until the New York Attorney General's office called us.
And what happened with the Attorney General's office?
Objection, Your Honor, calls for narration.
Your Honor, once again, this is just goes to Ms. Miller's experience with the investigation and with the fall of S&S Derivatives. That's important context, and the witness hasn't given an answer, so she's not narrating.
Sure. Mr. Greenberg, I'll just ask you to rephrase the question to be a little narrower of a question than just generally what happened with the Attorney General's office.
Yes, Your Honor. Shawn, were you contacted by the Attorney General's office personally?
Yes, I was. In about October of 2019, I was contacted by Sharon Holmes, and then he visited sometime in December.
And when Sharon Holmes contacted you, what information was he seeking, or was she seeking?
She asked a lot about Bernie Madlock, which was surprising to me. I mean, I hadn't talked to him in forever.
Objection, Your Honor, hearsay.
Your Honor, this is not being offered for the truth of the matter. It's a question. There's no truth value to the question. It's being offered for the effect on the listener, Ms. Miller, and her reactions to Investigator Holmes's questions.
Your Honor, may I be heard on that?
You may.
We contend that this question or this response is being offered for the truth of the matter. It is talking about the investigation itself and the contents of the investigation, specifically about the conspiracy. Therefore, this is for the truth of the matter.
Your Honor, we're happy.
At this point, okay, go ahead.
We're happy to keep out the truth value of whatever, or the truth that Mr. or Ms. Holmes was asking about these specific things. Again, we're using this for the effect on the listener.
And right now, the question is whether the witness was asked about Mr. Madlock. Is that right?
Yes, Your Honor.
I'll allow I'll overrule the objection and allow it. The question itself, I don't think it's hearsay, but of course, the witness should not testify as to any hearsay. So you may proceed.
So Shawn, you were saying about Investigator Holmes.
Yes, Investigator Holmes asked me about Bernie Madlock, which surprised me because I hadn't talked to Madlock in forever.
And what do you mean when you say forever?
I hadn't spoken to him since I left Beeman Brothers, which was probably sometime late 2016.
So Shawn, when did you find out about what was happening at S&S?
I found out early in 2020. I got a phone call in the middle of the day from my lawyer telling me to expect an indictment, but she didn't provide any details. And later that day on the news, I just kept seeing all these headlines about a huge fraud scandal uncovered at S&S, and I just couldn't believe it.
Invention of facts. The witness is inventing facts with that response.
May I be heard, Your Honor?
You may.
Your Honor, Miss Miller talks about her reaction and hearing the news in the fact pattern of the case, and elaborating just on that small detail is not invention of facts and could not materially alter the outcome of the case.
Overall, I'll allow the testimony. on it, as I don't think it will materially affect the outcome of the case. And I believe there may have been some reference to it, but you may proceed.
So Shawn, I want to be clear about a few things. Have you been in contact with Sydney since his trial?
No, I have not.
Shawn, did you ever knowingly falsify or send out false statements to your clients?
No, never.
Did you ever know or suspect that Sydney Taylor was committing fraud at SNS?
No.
One minute, please.
Thank you, Shawn. No further questions.
Cross examination, Ms. Geller?
Miller?
I'm sorry, you cut out for me. Could you repeat that?
Good morning, Miss Miller. That's all I said.
Oh, good morning.
You and Sydney have been friends since grade school, right?
Yes, that's correct. That's when we met.
You grew up in the same neighborhood too, right?
Yep, Far Rockaway.
You always had Sydney's back. Isn't that right, Miss Miller?
When we were kids, definitely.
And the two of you, when you were kids, aspired to be successful Wall Street stockbrokers. Isn't that right?
We definitely wanted to do better than what our parents had done for us, yes.
Was that a yes to my question?
Yes.
And you ended up going off to community college while Sydney went off to UPenn, correct?
Yes, she went to Wharton.
And at that time, when she went to Wharton, you stayed in constant contact with her. Isn't that true?
That's correct, yes.
According to you, you've always wanted to own your own securities firm. Isn't that right?
When I was younger, I'm not sure I knew what a securities firm was, but eventually when I was in college, yes, I did want to own my own firm, be my own boss. Sounded
yes.
cool. Yes.
And you accomplished this goal by launching SNS Derivatives in January of 2017, correct?
Yes, that's correct.
And at that time, Sydney was at Columbia University, right?
Yes, she was. She was doing her MBA program, I believe.
Regardless, she was still at Columbia while you were running SNS, right?
For the first few months, yes.
For the first few months, you mean first 8 months, correct?
Yes, it sounds about correct. From January to August.
So yes to my question.
Yes, that is 8 months.
And during that 8-month time period, you brought in all of the clients to SNS Derivatives, correct?
Yes, of course. I was the only person working there basically. So we started out as a new firm and I had to bring in clients, yes.
And many of those clients that you brought over were from your prior employer, Beeman Brothers, correct?
Yeah, some of them were. That is correct.
And that included Fran Ashcott and her husband, right?
Yeah, when Fran Ashcott found out that I would no longer be working at Beeman Brothers, she wanted to move her account right away.
And to entice new investors to SNS Derivatives, you promised them 10% returns or better. Isn't that true?
Objection, Your Honor, to hearsay.
Your Honor, may I be heard on that?
Yeah, yes, you may.
Your Honor, we are not offering any statements here. We are simply referencing the fact that Ms. Miller was encouraging investors to invest at SNS Derivatives with the 10% returns.
May I be heard, Your Honor?
You may, Mr. Greenberg.
The promises made or the encouragement given by Ms. Miller was previously kept out, I believe, on Ms. Holmes's examination. And these statements are still an out-of-court statement being offered for the truth that Ms. Miller, in fact, made these promises.
Would the promise as to the returns come under the state of mind exception, Mr. Greenberg?
Yeah.
Oh, I'm sorry. Go ahead, Ms. Geller. You could address that first. Go ahead.
I believe it does fall under the state of mind exception of hearsay due to this fact that this is her own statement and this is what was going on, what she believed during this time period.
Your Honor,
Mr. Greenberg,
I don't believe that these statements are admissible under the state of mind exception. State of mind is used to reflect the emotion or sensation of, as Rule 403 says, of the declarant, and these statements don't really offer information as to the emotion or sensation of Ms. Miller. these are not reflections of any immediate reaction of her to some news or some information, and thus they're not admissible under that exemption.
May I be heard, Your
Let me
Honor?
also ask, you go, you may, Ms. Geller.
Briefly, Your Honor. According to Rule 403, the state of mind, this does allow for statements that fall under plan. This was her plan for SNS derivatives, and therefore it is admissible under this exception.
And I'm going to overrule the objection. I think it may come under the state of mind exception, but also a statement as to the witness's promise. I don't think is being offered for the truth of that promise, but the fact that the promise was made. So I'll overrule the objection. You may ask the question.
Would you like me to repeat that question, Ms. Miller?
No, that's all right. I think I have a pretty good memory. We would often advertise our previous returns to our client, which were around 10% or that double-digit range.
So was that a yes to my question, Ms. Miller?
Yes.
And today you claim to have been in charge of client development, correct?
Client development and client relations, yes.
And Sydney oversaw all of the trading activities, right?
That is correct.
However, for the first 8 months that you ran SNS derivatives, you oversaw all of the trading activities, correct?
That is correct. There was no one else at the company.
Right. Even though you were taking advice from Sydney, it was you that was ultimately placing these trades, correct?
Objection, opposing counsel is testifying.
Overruled. You may answer.
That is correct. Again, I was the only person at the company. I was putting in these trading flips.
So yes to my question.
Yes.
And Sydney couldn't be directly involved at SNS derivatives during that time because she had a do not compete clause prohibiting her from being involved, correct?
Yes, she had her do not compete clause with Terrell Hinch.
So you knowingly conspired with Sydney to commit a breach of contract, isn't that true?
Objection, argumentative, Your Honor.
Overruled. Witness may answer.
Would you like me to question?
No, my answer is no. I did not conspire.
So you didn't help Sydney commit a breach of contract?
No, I don't believe so.
So you weren't receiving information from her while she was at Terrell Hinch?
I was, but Sydney's contract said she couldn't directly be involved.
And her giving advice to a competing firm, you would consider that to be not directly involved?
It's not just what I would consider, that was what was in her contract.
So you know the contents of her contract, Ms. Miller?
I do not exactly. It was not my contract that I signed, but Sydney did tell me that she was cleared to give advice.
Well, you just testified that you knew the contents of her contract at Terrell Hinch, isn't that true?
No, I did not.
I'm just going to move on. Let's discuss your FINRA licensing. You have a Series 6 and Series 7 license, don't you?
Yes, I do.
A Series 6 certification allows you to trade in mutual funds and variable annuities, correct?
That is correct, yes.
And a Series 7 allows you to be a stockbroker, isn't that true?
That is also correct. Those are the names of the exams.
And you were never certified for a Series 26, which is required for investment companies, isn't that right?
I did not have that Series 26 certification, but the Series 7 exam is quite broad and did allow me to trade derivatives.
Well, that wasn't my question, Ms. Miller. I asked that you were never certified for the Series 26, which is required for investment companies. Yes or no to my question?
Objection, a compound question about both the licensing for the exam and what the exam licenses people to do.
I can split the question if needed, Your Honor.
Just break up the question, Ms. Geller. Thank you.
So, Ms. Miller, yes or no, you were never certified for the Series 26, correct?
No, I never was.
And this certification is required for investment companies, yes or no?
I do not believe so. I believe you are incorrect on that.
So the Series 26 was not required for investment companies?
I do not believe so. SNS was fine and was a registered company as a hedge fund, and we were cleared and all set up to go.
Well, Ms. Miller, you were also never certified for the Series 31, which is required for trading in futures and derivatives, yes or no?
Objection, a compound question on the same grounds as before.
Again, Your Honor, I can split it up if need be.
Thank you.
So, Ms. Miller, you were never certified for the Series 31, correct?
No, I never took that exam.
And this exam is required for trading in futures and derivatives, correct?
That is incorrect.
So the Series 31 is not required for trading in futures and derivatives?
It is not the only exam that lets you trade in the derivatives market. My Series 7 would allow me to trade certain derivatives.
Well, when you launched SNS Derivatives, you didn't have a specific derivatives license yourself. Isn't that true?
I had my Series 7 again.
Which is not a specific derivatives license, correct?
There really is no such thing as a derivatives license. Different kinds of derivatives can fall under different exams. FINRA offers, I believe, a total of 65 exams, which is a lot of exams. And so just taking a couple of them can cover you to trade many different types of securities.
Thank you for that, Ms. Miller. Now back to my original question. So just to clarify for the record, yes or no, you did not have a Series 31 license?
No, I did not. And I didn't need one either.
So let's move on, Ms. Miller. Let's talk about Fran Ashcott. She moved her $3.5 million from Beeman Brothers to SNS Derivatives shortly after you opened SNS Derivatives, correct?
Yes, that is correct.
And there came a time where she called you and asked you about the status of her account beyond the monthly statements, correct?
That is correct, yes.
1 minute, please.
You assured Fran that her account was sound, didn't you?
Yes, Fran was concerned about how the company was making profit even in a bearish market, but I sat her down and I explained to her that we had tools to return a profit even in a downturn economy.
Thank you for that response, Ms. Miller, but that was not my question. I asked yes or no, you assured Fran Ashcott that her account was sound.
Yes, like I said earlier, I did assure her that her account was sound.
And she also wanted to know the basis of the firm's investment strategy, correct?
Yes, that is correct.
And yet again, you reassured Fran that her account was sound. Isn't that true?
I did that, and then I also directed her to Sydney if she had additional questions.
Well, Ms. Miller, you never independently verified Sydney's investment strategy, correct?
No, I did not. It was her responsibility she was handling the technical aspects of the investments.
Your Honor, I see that time is up. May I request just a few more questions just due to the objections? Thank you.
Sure.
So, Ms. Miller, even though you were only responsible for client development, you still felt confident enough to give those assurances, correct?
Again, like I said, Fran was concerned about the general economy, and I did reassure her that everything was going to be okay with her account because we did have tools to return those kinds of profits.
Ms. Miller, that was just not my question. Even though you were solely responsible for client development, as you just testified on the stand today, you felt confident enough to give her those assurances, yes or no?
Yes, I did.
And you based this decision on trust of Sydney Taylor rather than personal analysis of Sydney Taylor's investment strategy, correct?
Yes, I did.
And now let's just move on briefly. The Attorney General began an investigation of SNS Derivatives, correct?
Yes, they did.
That was shortly after the SEC started an investigation into SNS's investment strategies, right?
Objection outside the scope of the direct examination.
I'll allow a little leeway here, overruled.
Would you like me to repeat the question?
No, that's all right. It was a few months after, I believe.
And you didn't become suspicious about the SNS investment strategy at any point?
No, I never did. Even when the SEC contacted us, they dropped their investigation soon after. So no, I wasn't suspicious.
So Ms. Miller, do you believe that securities fraud was committed at any time at SNS Derivatives?
I really don't know. I wasn't at Sydney's trial. Everything that I'm hearing today about flash drives and trading slips, this is all the first time that I'm hearing all of this. So I really don't know how to answer that question. I'm sorry.
Well, Ms. Miller, let me help you out here. Sydney Taylor was found guilty of securities fraud, wasn't she?
She was convicted, yes.
And you are part of the same indictment that we brought against Sydney Taylor, correct?
Oh man, I don't know about these lawyery terms. I don't know. I thought our trial was split, but I don't know how that technically works out.
So you are unaware whether or not your name is on the indictment of the proceedings that we are in today?
I know my name is on a indictment. I don't know how exactly those papers look together.
Now, just one more question, Ms. Miller, or just two more questions, sorry. Isn't it true that you believe that if the Attorney General hadn't investigated, then SNS wouldn't have lost any money going forward?
Objection. The question calls for speculation.
Your Honor, may I be heard?
You may.
This witness is well aware of the response to this question. It is contained within her affidavit.
Your Honor, may I be heard?
Go ahead. Yeah.
That's not just because something is in Ms. Miller's affidavit isn't sufficient to make it not speculative. Asking Ms. Miller to guess about what would have happened in an alternate universe or in a different set of events certainly calls for speculation.
Yeah. Sustained. If you have any more questions, you may ask them.
Yes, just one last question, Ms. Miller. Please tell the court where Fran Ashcott's $3.5 million is.
Objection. Argument.
Your Honor, may I be heard?
You may, go ahead.
I'm not asking this witness to infer on the facts. I'm merely seeking additional facts about where the money of that her investment company is now currently.
Yeah. I'll if the witness is able to answer the question, I'll allow the question.
I don't know.
Thank you, Ms. Miller. Nothing further.
Mr. Greenberg, redirect?
No redirect, Your Honor.
Okay. Ms. Miller may step down, and the defense may call its next witness.
Your Honor, defense calls Ms. Nikki Penman to the stand.
And Ms. Bergner-Phillips, you may proceed whenever you're ready.
Thank you. Good afternoon. Please state your name for the record.
My name is Nikki. My name is Nikki.
There appear to be some audio difficulties, if you'll give us a moment.
I apologize.
I apologize, Your Honor, for the interruption.
No worries. That's the world we've been living in, so I'm accustomed to it.
I'm so sorry. Oh. Okay.
I believe the other person in the room just has to shut off their volume, and that should fix the problem.
Yeah, okay. I'm so sorry. Can you hear me properly now?
We got you now. I think that's working.
Apologize.
No
Your Honor,
worries.
may I proceed once again?
Yes.
Good afternoon. Please state your name for the record.
Good morning. My name is Nikki Penman.
Good morning. What do you do for work?
I'm a CPA. I've been licensed in the state of New York for 34 years and in the state of New Jersey for 29, but most of my work is as an auditor.
Where did you go to school?
I have a bachelor's from CUNY Roosevelt, summa cum laude, and a master's in taxation from Bricker University. I also have a PhD in accounting.
Where did you go to work after school?
Well, I worked for my father's accounting practice when I was young and actually interned for Arthur Andersen while in college. I later worked there for 13 years, but I eventually left.
Why did you leave Arthur Andersen?
So I had plans to leave Arthur Andersen in 2001 when I was made manager, but not partner. You know, I wasn't really moving up, but in the end, Andersen was actually shut down right as I was about to leave.
To the best of your knowledge, why was the Andersen firm shut down?
Objection calls for narration.
Overruled, I'll allow the answer.
My boss pled guilty to obstruction of justice related to the Enron audit, and the firm was destroyed.
Where did you go on to work after Arthur Andersen?
So after some years working private contract jobs, I got a job offer at the firm Meal and Mucci, or M&M, as we like to call it. It's a great firm, and I've been partnered there for around 7 years.
Ms. Penman, what, if any, is your involvement with the case at hand today?
So my firm, M&M, was the outside auditor for SNS Derivatives. My colleagues and I worked very closely assessing the fairness and validity of their financial statements. I also happen to be Shawn's personal accountant.
I want to now talk more about your work as an auditor. How do you begin conducting an audit?
Sure. So my firm, M&M, generally audits complex companies. So we start by looking if the company's financial statements comply with regulations. We follow very strict protocols and make sure to work as a team when assessing the risk of material error and when formulating an opinion of the fairness of the financial statements provided to us.
What protocols do you follow?
All kinds of protocols. We follow the Sarbanes-Oxley requirements and the PCAOB requirements, which are the new Public Company Accounting Oversight Board requirements.
Do you have any standard procedures that you follow when conducting an audit?
Absolutely. So when auditing any complex company, we first perform analytical procedures where we cross-check the data to detect errors, inconsistencies, or possible omissions. And then we evaluate the company's internal controls in depth.
What types of evidence do you collect during the course of an audit?
All kinds of things, from financial statements, the income statement, the balance sheet, the statement of retained earnings, and the cash flow. We even perform tests of the account balances and go as far as to observe while the client is taking inventory.
In your experience, is there any risk that an audit might miss something?
You know, there's always a small risk that an audit could miss something. To be 100% sure, you'd have to recreate every single transaction. No, there just isn't time to do that. So as is a standard in my field, we use a representative statistical sampling of accounts payable, follow all auditing standards, and confirm purchases.
Can you explain what you mean by saying you confirm purchases?
Sure. So we actually contact the people who sell securities to the company, this like the clearinghouse or the vendors organization, asking for a written confirmation of the trades, the dates they happened, the amounts involved, and what those securities actually were.
Your Honor, at this point, the defense moves to enter Nikki Penman as an expert in auditing.
Voir dire, Your Honor.
You may.
Ms. Penman, isn't it true that you lost your job pursuant to the Enron scandal at Arthur Andersen in 2001?
Yes, that's true.
You thereafter didn't have steady employment as a certified public accountant for nearly 20 years, correct?
I was employed actually for most of that time.
You didn't have steady employment though, correct?
No.
And Ms. Penman, finally, isn't it true that while at Meal and Mucci, you failed to find abnormalities in the audit of your SNS derivatives?
Yeah, we did. And, you know, it really goes to show how complex and sophisticated this conspiracy really was.
So you did not find any abnormalities, correct?
We did not. You're right.
Your Honor, Ms. Penman lost her job after the Enron scandal at Arthur Andersen. She did not have stable employment for almost 20 years, and you're going to hear in a moment that this witness was shredding documents at Arthur Andersen, which her boss was convicted of for obstruction of justice. She also, she also has not published any works in the fields of accounting and audits to establish her expertise. So most of the time she was either shredding documents, not unemployed, or not conducting a proper audit. Therefore, this witness does not have the qualifications to become an expert in today's proceedings.
Your Honor, may I be heard?
Ms. Bergen-Phillips? Yeah.
If I may, to begin with, opposing counsel made several assertions, which, if I may proffer, the witness would certainly disagree with, and which were not covered in any testimony. But furthermore, mock trial evidentiary rules require that a witness either have education or experiential background. Ms. Penman has both, with a master's degree in taxation, a bachelor's, a PhD in accounting, and decades of experience. And if opposing counsel wishes to probe the period of time in Ms. Penman's life where she worked private contract jobs, he's free to do so on cross-examination.
I will. I'll qualify the witness as an expert in. And I'm sorry. What's the proffered expertise?
In auditing.
In auditing. Given her educational and work experience, notwithstanding the period after she left Andersen, where work was less regular, but cross-examination may be allowed on her qualifications and the weight that the jury should give any expert opinions she provides.
Thank you, Your Honor. Ms. Penman, I want to now turn your attention to the case at hand today. To what extent did you work as a team when evaluating SNS?
You know, we held team meetings, which were extremely important to our understanding of the audit. Sydney's investment strategy was exceptionally complex, so we need to brainstorm and consult amongst ourselves. Working in a group is an effective strategy in minimizing errors and oversight.
How was Sydney's strategy complex?
It included credit default swaps, forward contracts, and futures, all types of securities which require a highly specialized knowledge of the market.
Did you take any steps to minimize risk when conducting the audit of S&S?
We absolutely did. So as I mentioned, we followed all applicable auditing standards. We confirmed purchases as well. And in this case, we got even more confirmations than usual.
Why did you get even more confirmations than usual?
Well, because of some initial concerns about the rates of return, which were quite high.
Ms. Penman, at the end of your audit, what did you ultimately conclude?
We concluded that nothing was wrong. Based on our analytical procedures and our integrated audit, including through the confirmations and the follow-up confirmations, no fraud or anything of that nature was uncovered.
Are you aware now that there was fraud occurring at S&S Derivatives?
I am.
So does the fact that you missed the fraud tell you anything about how it might have been conducted?
Absolutely. So as I mentioned before, Sydney's investment strategy was quite complex, and the fact that from our review on the auditor side, the internal controls seem sound suggests to me that the fraud was conducted by the top management, namely the side revolving around the technical aspect of the firm.
How did you reach that conclusion?
So internal controls, which are a really important part of my job, prevent employees from reporting fraudulently, but when the top managing investor is committing fraud, it's almost impossible to detect.
So what is your understanding as to how the fraud was undetectable?
It's very likely that the fraud was conducted with the vendor's organization, Sturgeon Manley. We received documents from Sydney at S&S and confirmations from Bernie Madlock at Sturgeon Manley, and they were consistent. That suggests to me that the fraud must have been happening from both ends, with the vendor's organization and with whoever at S&S actually interacted with the vendor.
Thank you, Ms. Penman. Thank you, Your Honor. No further questions.
Mr. Macon?
Yes, cross-examination, Your Honor.
You may proceed.
Ms. Penman, isn't it true that you worked for Arthur Andersen?
I did work at that firm, yes.
Isn't it also true that at Arthur Andersen, you were asked to shred documents in furtherance of the Enron scandal?
Yes, that's true.
Moreover, isn't it true that your boss at Arthur Andersen pled guilty to obstruction of justice for the shredding of those documents?
Do you mean the documents that were shredded throughout the scandal, or just my documents?
For the shredding of the documents that you shredded.
Objection, Your Honor. Other crimes, wrongs, and acts are inadmissible.
Your Honor, may I be heard?
You may.
Your Honor, this is admissible under Mock Trial Rule 202. It is attacking this witness's credibility as well as her truthfulness. Therefore, it is admissible today.
Your Honor, may
I will let, go ahead. You may.
The fact that Ms. Penman shredded documents, which, if I may proffer, was directly following her firm's policies, does not indicate a quality of truthfulness. Further, Your Honor, if I may, this incident occurred decades ago in accordance with company policy. No punishment or charges came out of it. And members of the jury will hear this and will have preconceived notions about the famous case of Enron and Arthur Andersen, and will be unfairly prejudiced. So the probative value of introducing this decades-old action is substantially outweighed by unfair prejudice.
I'm going to not allow any questioning about any prior conviction, whether by Andersen or by the witness's former boss, but there may be cross-examination on the acts taken by the witness.
Yes, Your Honor. So, Ms. Penman, you shredded documents at Arthur Andersen in furtherance of the Enron scandal, correct?
Yes, I know that now.
And Ms. Penman, you were a certified public accountant at Arthur Andersen, right?
Yes, I was.
As a CPA, you were never trained to shred documents, right?
No, we were trained to shred documents.
And isn't it true that by shredding those documents, you obstructed the ability to conduct a proper audit of Arthur Andersen?
I'm not really sure.
You're not sure, as the expert in audits, that shredding financial documents would obstruct the ability to perform a proper audit?
let me explain this for the jury. So shredding documents is a really important job in all firms. You know, we have to protect
Ms.
important.
Penman, that wasn't my question. My question was, by shredding those documents, you obstructed the ability to conduct a proper audit, correct?
Objection, Your Honor. This question calls for the witness to reach a legal conclusion. She has no experience that would allow her to reach this.
Your Honor, may I be heard?
You may.
Your Honor, this witness is an expert in audits, therefore she can testify to what would be included in an audit and if the ability to conduct an audit would be obstructed in any situation.
So I'll allow it, although the use of the term obstruction is not the legal term obstruction, but more interfere or get in the way with. But I'll allow the questioning.
So, Ms. Penman, isn't it true that by shredding those documents, you interfered with the ability to conduct a proper audit at Arthur Andersen, correct?
No.
Not by shredding documents, you didn't interfere with the ability to conduct an audit?
Shredding documents in general? No, I don't think so.
But you still did shred those documents, correct?
I did shred documents, yes.
And by shredding those documents, there was not all of the information at Arthur Andersen was present for an audit to be conducted, correct?
I'm not sure what you mean. Those documents were shredded, I think after we did the audit. I'm not really sure.
By shredding those documents, Ms. Penman, not all financial information was present at Arthur Andersen.
Objection,
correct?
Your Honor. Asked and answered.
Overruled.
Could you repeat the question?
Ms. Penman, by shredding those documents, not all financial information was present at Arthur Andersen to conduct a proper audit, correct?
I'm not sure. I didn't know what those documents were, so I'm not sure.
You didn't know what the documents that you were shredding were?
I didn't read them over. I couldn't even recall them from memory.
So
This
as a
was so long
certified
ago.
public accountant, you shredded documents that you had no idea what they were, just to clarify.
This was a huge audit, Enron. Yeah, I guess that's a yes to your question.
Now, Ms. Penman, while auditing for S&S derivatives while in your position at M&M, you have described protocols and procedures for how you've conducted those audits on direct. Now, isn't it true that you did not see every single financial statement, but instead just a sampling of those statements?
Yes, that's a standard in our field to know polar statistical sampling.
And you can never be sure that there are 100% no errors or omissions, right?
Yes, that's true.
You even said people are people. They get sloppy, right?
Yeah, I believe I did say that.
Now, you've described audit season as rush, 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 right?
It definitely is, yeah.
So, like you testified on direct, you didn't recreate every single transaction, right?
That would be, yeah, virtually impossible. You know, that's why we like to do interim work over the summer. You know, we're not doing the entirety of the audit in like a month. We really like to take our time.
Thank you, Ms. Penman. So, but it is entirely possible to request every single transaction, correct?
Sure. I mean, it's possible.
But your company uses statistical sampling in your audits because it would be too expensive to check every single file, right?
Yeah, that's true.
But it's still entirely possible to check every file, right?
Totally honest with you, I haven't even heard of a firm who checks every single file, but I guess that's a yes to your question.
And you pay your staff well, correct?
Yeah, we do.
You also have stated that you've paid the extra expense to train 2 people using job share, right?
Objection, Your Honor. Relevance.
Your Honor, may I be heard?
You may.
This is subject to connection as to what Ms. Penman did utilize funds at Milamucci for, and what she did not utilize funds in her audit of S&S derivatives for.
I'll allow a little cross-examination on this.
You
may
so
proceed.
would you like me to repeat the question, Ms. Penman?
Yeah, that would be great.
You also pay the extra expense to pay 2 people while using job share, correct?
Yeah, absolutely.
You've even said that a little extra money could solve an auditor's personal problem at the firm, right?
Objection, Your Honor. Hearsay. opposing counsel is calling for the witness's prior out-of-court statement. You've said this statement before.
Your Honor, may I be heard?
May.
I'm simply asking this witness if they agree with the statement that they have said. They can answer yes or no to the question if they would like.
I'll allow it. I don't think it's being offered for the truth, so I'll allow the question.
Now, you even said that a little extra money could solve an auditor's personal problem at the firm, correct?
I'm not sure. Well, yes.
Now, despite all of these other expenses at Miele and Mucci, you still didn't pay the money to check every single file of S&S derivatives?
I personally didn't. No.
And you are a partner at Miele and Mucci, correct?
Yes, I am.
So you would be the one to request the more confirmations and pay for those confirmations, correct?
We did request many more confirmations, actually.
But you did not check every single file, right?
No, we did not. Of course not.
So it's entirely possible that you could have missed a piece of evidence that was incriminating towards Shawn Miller since you didn't check every file, right?
Objection, Your Honor. Question calls for speculation.
Your Honor, may I be heard? Ms. Penman is an expert in audits. Therefore, she is allowed to answer questions, hypothetical questions based on her audit.
Your Honor, if I may be heard.
Go ahead.
Ms. Penman has repeatedly testified to the fact that the firm, that in her work, in her work experience in the firms that she has been at and the firms that have allowed her to testify as an expert, they only use representative statistical sampling, thus she can't speak to a hypothetical firm that doesn't use the same procedures.
I'll allow the question in the event the witness is able to answer the question, but I note the objection. Thank you.
So, Ms. Penman, since you did not check every single file, it's entirely possible that you missed a piece of evidence that could have been incriminating towards Shawn Miller, correct?
I don't think so. I think the confirmations that we were getting were confirmations of trades that apparently never happened.
Thank you for that answer, but that wasn't my question, Ms. Penman. It's entirely possible that you missed a piece of evidence that could have been incriminating towards Shawn Miller since you did not check every single file, correct?
No.
And that piece of evidence could have linked Shawn Miller and Sidney Taylor as co-conspirators, right?
I believe I
Your Honor, I'd like to.
Go ahead.
Your Honor, I would like to raise my speculation objection to opposing counsel's previous question. This extends far beyond the bounds of her understanding as it asks for her to draw a conclusion as to whether or not Sidney and Shawn could have been linked legally as co-conspirators based on evidence, which is certainly not her job as an auditor.
Your Honor,
do you have any more questions along this line?
No, I can move on if you'd like, Your Honor.
I think you can move on. You can move to your next point.
Now, you've stated that the audit of S&S derivatives was not simple, correct?
Correct.
In fact, it was quite complex, requiring a very specialized knowledge of the market and the economy, right?
Yes, that's correct.
Now, due to this complexity, your firm decided to increase the scope of your audit and request more confirmations, right?
No.
You didn't request more confirmations?
Oh, no, we did, of course, request more confirmations, but that was more in response to other aspects of the audit.
But did requesting more confirmations help in uncovering the fraud at S&S?
No, it didn't. And I believe no matter how many confirmations we received, I don't think it would have made a difference.
So that's a no, correct?
Yes, that's a no.
You still missed that the reporting of these investments were actually fraudulent, correct?
I'm sorry, could you repeat the question?
You still missed that the reporting of these investments were actually fraudulent, correct?
Yeah, we did.
And isn't it true that you believe when top management conspires to commit fraud, it is virtually impossible to discover?
Yes, that's true, especially on the technical side.
So Sidney Taylor is a principal of S&S derivatives, right?
Yes, he is.
Shawn Miller is also a principal of S&S derivatives, right?
Yes, he is.
And yes or no, Ms. Penman, you would consider them both to be top management, right?
Yeah.
Moving on.
Your Honor, if I may just draw your attention, I'm not sure if others noticed, but time was called a few minutes ago. I just wanted to draw attention to that.
So, yes, we had a couple of objections, so I'll allow a very little more. Mr. Macon, do you have much more on cross?
Yes, I just have a few more questions, Your Honor.
Yeah, thank you.
Now, Ms. Penman, you've known Shawn Miller for over 8 years, correct?
Yes, that's true.
Furthermore, you are Shawn's personal accountant, right?
Yes, that's true.
And you still took the lead in the audit of SNS derivatives despite your relationship with one of its principals?
A relationship, like a romantic relationship?
A professional relationship, Ms. Penman.
Yeah, you know, it's actually totally normal for us, the auditors, when we're auditing a huge firm, to actually be the personal accountants for the executives.
So you still took the lead in the audit despite your relationship, yes?
Yeah. Yes.
You would consider this to be a conflict of interest?
Oh, no, not at all. Not
But
at all.
if Miss Miller is convicted today, you lose a long-term paying client, right?
I guess.
And you trust Shawn implicitly, correct?
Yes, that's true.
And you want Shawn to be exonerated, right?
I mean, I guess. I don't know.
So is that a yes to my question? You want Shawn to be exonerated?
Yes.
Thank you, Your Honor. Thank you, Ms. Penman. Nothing further.
Is there a redirect, Ms. Bergner-Phillips?
No redirect, Your Honor.
Okay. Well, thank you. The witness may step down and the defense may call its next witness.
Your Honor, the defense calls Ryan Williams to the stand. Sorry, okay, there you are. Good morning, Miss Williams.
Good morning.
Could you please state your name for the record?
My name is Ryan Williams.
What is your involvement in this case?
I'm here to testify as Shawn's former superior. I think of myself as her mentor and longtime friend. I've known Shawn for almost 15 years.
Where did you go to college?
I went to UPenn and I got my BA in finance there. And then after that, I went to the Yale School of Management.
And what did you do after college?
I was really lucky, actually. Right after college, I got hired with Beeman Brothers, which is one of the biggest investment banking firms on the street. And that's actually where I met Shawn.
What did you do at Beeman Brothers?
For years, I had this job I loved as one of the top investment bankers at Beeman Brothers. And then after about 20 years, I was promoted to manager of their mortgage-backed securities division. And I worked there for another 5 years until the company closed down.
From what you know, why did Beeman Brothers close down?
Well, the market had a pretty tough period in 2019, and Beeman got hit hard. It was such a surprise to me and the world at the time. I think I saw us on the news maybe 10 times.
Objection, Your Honor. I move to strike the latter portion of that response as non-responsive.
Your Honor, if I may, Ms. Williams was simply elaborating on why Beeman Brothers closed down. She was adding additional necessary context.
May I be heard?
Well, go ahead. Go ahead, Ms. Fernandez-Vaughn.
Yes. Well, opposing counsel's question specifically asked her, to her knowledge, why did it close down? And the latter portion of her response was her reaction to it, which, Your Honor, is not responsive to her question.
I'll strike the second part of the answer and just allow the response about why it closed down. But if you wish to ask additional questions, you may, Ms. Penman.
Yes. How did the collapse of Beeman Brothers affect you, Ms. Williams?
So financially, I was all right, but I was upset. I felt like the media was just looking for a scapegoat. You know, sometimes these things just don't have easy answers. No matter how strong an investment can seem at the start, even good investments can fail.
Objection, Your Honor. Improper opinion. That latter portion of the response would require expert knowledge, and Ms. Williams has not been deemed an expert in today's proceedings.
Your Honor, may I respond?
You may.
Your Honor, Ms. Williams has just previously testified that she worked at Beeman Brothers, an investment company, for over 20 years, and she was a manager of their mortgage-backed securities division. She has adequate knowledge to testify that good investments can sometimes fail, about how strong an investment may be. This is well within the scope of her knowledge.
I'm not sure it was particularly responsive, but I'll allow the testimony. I think it was pretty uncontroversial point, so I'll allow it.
Thank you, Your Honor. Ms. Williams, how did you first meet Shawn Miller?
I met Shawn Miller when she was working in the mailroom at VIII Brothers. I like going around the office to meet other young employees with a lot of potential. Like I always say, it's nice to be important, but it's much more important to be nice.
How did your relationship evolve with Shawn?
As soon as I started talking to Shawn, she struck me as really bright. I thought we should talk a bit more and see if Shawn would be successful at anything else in our company.
What was your relationship like with Shawn?
Shawn and I actually became very good friends, and we were able to talk about almost anything. Shawn was determined to go up in our company, and I thought we should talk more about that.
So how did you help Shawn advance at the company?
Well, first, Shawn and I started getting these weekly lunches where we talk about her career as well as any Wall Street buzz. I thought Shawn would need some sort of informal education on everything business related before she could really take off at VIII.
Did Shawn ever get promoted from the mailroom?
Yes, she did. I got Shawn an entry-level job as a salesperson at VIII. Shawn was pretty good with people, so I wanted to give her a shot at being a salesperson. And she was actually pretty good with clients, though it was clear she needed to up her technical game, so I recommended she take the FINRA exams.
Why did you recommend she take these FINRA exams?
Well, even though Shawn did have a pretty basic knowledge of the business world, I wanted to give her a chance to become a real salesperson. If you pass the FINRA exams, it licenses you to become a stockbroker. If Shawn wanted to take in more clients or get promoted at VIII, it would be a really good idea for her to take these exams.
What strengths did she already have to become a salesperson?
Shawn was definitely a people person and enjoyed doing what she was best at, talking with clients. She really cared about building strong relationships with them.
Did she have any notable weaknesses?
Compared to the other traders in the office, her education wasn't quite as advanced. The FINRA exams were a good step for her. It did take her 7 tries to pass them, but they helped. We were always looking for ways for her to solidify her skill set anytime we had time.
Your Honor, I move to strike that latter portion of the response as non-responsive. The ways they were looking to improve her were not responsive to the question.
Your Honor, may I respond?
Go ahead.
Ms. Williams just testified to Shawn's notable weaknesses, and she was simply elaborating on the effect that those noticeable weaknesses had and how they worked on them. It's all relevant to those weaknesses.
I'll allow the answer. I'll give a little bit of leeway here for the answer going a little bit beyond the question.
Thank you. Ms. Williams, what sorts of things did you discuss with Shawn?
Shawn and I would talk about a wide range of things. Our lives, sports, work, family. One day we might be talking about economic recovery. The next day we could be talking about the Wells Fargo scandal.
What general advice did you give Shawn about the business world?
Look, it's tough to be in this business. I told Shawn about what it would take to succeed as a woman on Wall Street. People want any reason to take down their competitors, and I told Shawn never to give them one. I reminded her not to forget the bigger picture, her responsibility as an honest broker.
Do you think Shawn lived up to these ideals at VIII Brothers?
Objection, Your Honor. Speculation.
Your Honor, may I respond?
You may.
Ms. Williams has already established that she was Shawn's mentor for years. They worked together at VIII Brothers. She closely observed Shawn's professional manners. They had a very close working relationship. She's already established that she has the knowledge to give this opinion about Shawn's work.
You may.
Your Honor, Ms. Williams is the manager of the mortgage-backed securities division. She was not the manager of the junior sales associate. Shawn Miller was not
watching this. I want to see if Nina comes up. It's mock trial. They're on the finals.
Oh.
I think someone.
Yes, Your Honor, may I respond to that? Excuse me, sir.
Is this character? Can you address whether are you offering this as character evidence under Rule 202?
Yes, Ms. Williams is here to testify about Shawn's character and capability, and beyond just being the head of the mortgage-backed securities divisions, she also had a very close relationship with Shawn, one like a mentor and a mentee.
I'm going to allow the testimony, the objections overruled. Thank you.
Ms. Williams, I'll repeat the question. Do you think Shawn lived up to these ideals at Beeman Brothers?
Absolutely. I have a lot of faith in Shawn's character. It was clear at Beeman that she looked out for her clients. She would admit her mistakes, and she would always give honest feedback.
Ms. Williams, what was your reaction when you heard of the allegations against Shawn?
I was horrified. I knew practically as soon as I heard that Shawn couldn't have done this. Shawn is a client person, not a technical person, and based on what I know about the fraud, with Shawn's technical experience, I honestly don't think she could have done this. And
Ms.
of
Williams,
course, as soon as I...
Apologies.
Oh, sorry. Well, yeah, go ahead.
Ms. Williams, why are you testifying here today?
I'm here today because it's clear to me that this investigation just got some things wrong. Trust me, Shawn, both on a personal and a skill level, is not the person responsible for anything like this.
Thank you, Ms. Williams. No further questions.
Cross-examination, Ms. Hernandez-Ramos.
Yes, Your Honor. May I proceed?
You may.
Good morning, Ms. Williams.
Good morning.
Now, Ms. Williams, you've stated on direct examination that defendant Shawn Miller is your friend, correct?
Yes, we're friends.
You're here to vouch for your friend, Shawn, right?
I'm here to talk about her character.
And by doing so, you're vouching for your friend, Shawn, correct?
Yes, I believe so.
And you also met defendant Shawn Miller while she was working in the mailroom at Beeman Brothers in 2008, correct?
That is correct, yeah.
So you've known her for about 14 years now, right?
I think just about.
Soon after meeting Shawn, the two of you had monthly meetings to discuss the investment industry. Isn't that true?
For about 2 years, yes.
And during your monthly meetings, you stated on direct examination that you talked about all sorts of things, correct?
That's right.
And part of that would be the illegal trading activities that you had seen on Wall Street, correct?
Yeah, exactly. Goldman Sachs had their illegal trading thing in 2009. We'd always talk about things like that.
Essentially, you were her mentor, correct?
Yeah, we're friends and mentors, sure.
These meetings were mostly for you to teach Shawn about the American economy. Isn't that right?
Well, you know, we got distracted, talked as friends, but I did want to give her sort of an informal education.
Is that a yes, Ms. Williams?
Yes, that's a yes.
Isn't it a fair statement to say that you've been accused of improper trading activities during your tenure at Beeman Brothers?
By a few journalists, I was accused.
So that's a yes?
Yes, that's right.
Isn't it true that in October of 2019, Beeman Brothers collapsed due to improper trading activities as well?
Unfortunately, it did.
And you were the manager of Beeman Brothers' mortgage-backed securities division from 2014 to 2019, correct?
Yes, of their mortgage-backed securities division.
By the way, Ms. Williams, what is a mortgage-backed security?
A mortgage-backed security is a security that deals with different mortgages and what they are priced at and their influence in the industry.
Is that the extent of your knowledge on a mortgage-backed security?
I mean, no, of course not. I could go on for hours, but that's the base level.
In 2010, you helped Shawn obtain her position as a junior sales associate at Beeman Brothers, correct?
I did.
And you got this job for Shawn by calling in a few favors from your colleagues at Beeman Brothers. Isn't that right?
Yeah, we thought she was pretty qualified, so I did.
And because you thought she was pretty qualified, you also encouraged her to take the necessary examinations to become a licensed stockbroker in 2012, right?
Well, I thought she would need it to advance her career, so I did.
In fact, you sponsored her for her Series 6 and her Series 7, correct?
Yes, like I said, I thought she was lacking in the technical area, so I thought she'd need the exams.
Ms. Williams, what's the difference between the Series 6 and the Series 7 licenses?
Series 7 exam focuses more on derivatives, and a Series 6 is more of just your base level qualifications.
You're aware that the primary investigator on this case is Sharon Holmes, correct?
Objection, Your Honor.
I'll allow this question as to whether she's aware of that who the investigator is.
Okay.
You can answer that question now, Ms. Williams.
I believe it is. Yes, Ms. Holmes.
And you dislike Investigator Holmes, correct?
I don't trust her necessarily.
Your Honor, I'm re-raising my objection to relevance.
Ms. Fernandez-Ramos, what's the relevance of this line?
To establish bias, Your Honor.
And is there a response, Ms. Tamalata, to bias?
Your Honor, Ms. Williams' opinion of another witness in this trial has no effect on her reasons for testifying on behalf of Shawn. She's here to talk about Shawn's character and capabilities, and furthermore, I do not believe opposing counsel has laid adequate foundation as to the bias at this point.
Your Honor.
Ms. Hernandez-Ramos?
We're in the process of establishing foundation for this witness's bias, not only towards the main investigator on the case who brought the prosecution of Shawn Miller, we're also establishing bias of the actual prosecution as well.
Your Honor, may I respond?
You may. Go ahead.
Your Honor, the probative value of Ms. Williams's views about the investigator in this case does not add any additional value to her testimony on Shawn. It bears no weight for her beliefs about Shawn, which is why she's here to testify today. Instead, it creates an unfair prejudice in front of the jury as to the way she characterizes other people.
I'm going to overrule the objection. I'll allow this line of questioning. You may continue.
You can answer that question now, Ms. Williams.
Sorry, would you repeat it?
Of course. You dislike Investigator Holmes, correct?
I don't trust her.
You believe that she's a real loser, isn't that right?
Well, I think she had a failed career in the finance industry, and then the first thing she does is come back and prosecutes the finance industry. So, again, like I said, I don't trust her.
Ms. Williams, well, that wasn't my question. Please answer in a yes or no format. You believe that Investigator Sharon Holmes is a loser, correct?
Objection. Your Honor, asked and answered.
Overrule.
You can answer that question now, Ms. Williams.
Sorry. Yes, I said yes.
Yes?
Yes.
Moreover, you believe that the criminal prosecution of the defendant, Shawn Miller, is unwarranted, don't you?
Sorry, you cut out for a second. Would you repeat that?
You believe that the criminal prosecution of Shawn Miller is unwarranted, don't you?
I do believe so, yes.
You also believe that the criminal prosecution is malicious, isn't that right?
Yes, I do.
To relevance.
Overruled. You may.
And Ms. Williams, it's also fair to say that you're not fully familiar with all the evidence in today's proceedings, isn't that correct?
I wasn't asked to review all the evidence.
That was not my question, Ms. Williams. You are not.
Sure. So I'm not aware of every piece because I wasn't asked to review it.
And so then, Ms. Williams, it's also fair to say that you believe that Shawn is innocent based on the friendship rather than all the evidence in today's proceedings, correct?
Well, like I said, I saw Shawn for years in a work environment, so I do believe she's innocent. And I was not asked to read the evidence, so I didn't read it.
Is that a yes then?
Yeah, that would be yes.
Now, Ms. Williams, you previously stated that you were in contact with Shawn after she left VIII Brothers, correct?
I was. That's correct.
However, you haven't physically worked with Shawn since 2016, correct?
No, I have not.
And even when you did work with Shawn, you were in a completely different department, correct?
That's true, but there was some overlap.
Now, it's been about 6 years since you last worked alongside her, correct?
I believe so, yes.
So it's a fair statement to say that you don't know what Shawn was up to on a daily basis over at S&S Derivatives, correct?
We would talk every couple weeks, but I didn't know what she was doing every minute.
You also don't know specifically if she was preparing the monthly statements, correct?
I'm sorry, I don't know what you mean.
Outside of the scope of my direct examination.
Your Honor, maybe her.
Yeah.
I'm
Go ahead,
simply
Ms. Hernandez Ramos.
Hmm?
Go ahead.
I'm simply asking whether she does or does not have this information within her personal knowledge.
Town Black, was there testimony on direct about whether this witness thinks that Mr. Miller is guilty?
Yes, there was some testimony from Miss Williams about her beliefs as to Shawn's truthfulness and character, and therefore why she believes Miss Miller is innocent. She is
Ms.
here
Miller,
testifying on Miss Miller's behalf today. However, there was no mention of the client statements, their relationship past the point of the FINRA exams, or any of what Shawn was up to at S&S Derivatives, which would be anyways beyond
I'll allow a little more questioning on this. You may continue, Ms. Hernandez Ramos.
You can answer that question now, Ms. Williams.
Sorry, would you repeat it for me?
Of course. You don't know specifically if she was preparing the monthly statements, correct?
I'm not even sure to which monthly statements you're referring.
Just the monthly statements at S&S.
I didn't work there, so I have no idea.
You, as you stated, you can't state with absolute certainty what occurred at S&S because you weren't there, correct?
Yeah, of course not.
Now, let's move on. Shawn left Beeman Brothers in November of 2016, correct?
She did.
And when she left Beeman Brothers, she stole Beeman clients. Isn't that right?
She took some of her clients with her.
And you claim that this didn't bother you, even though you were still working at Beeman Brothers at the time that she left, correct?
in relevance.
Ms. Hernandez Ramos, dress relevance?
Yes, Your Honor. This goes to establish this witness's bias in favor of the defendant.
Your Honor.
Go ahead.
Your Honor, Ms. Hernandez Ramos has already put forward a number of points about Ms. Williams's bias towards Ms. Miller that has already been sufficiently established. Her personal feelings about whether or not Shawn stole clients from Beeman Brothers does not add additional probative value.
I'll overrule it. You may ask a question, Ms. Hernandez Ramos.
You can answer that question now, Ms. Williams.
No, it's a pretty standard practice for people to take their clients with them to a new firm, so it didn't bother me.
However, Shawn Miller was just the junior sales associate at Beeman Brothers, correct?
Yeah, she was.
Now, Ms. Williams, if Beeman Brothers were to lose clients, then they could lose profits as well, correct?
Yeah, I'm sure.
And if Beeman Brothers were to lose clients, as one of the managers at Beeman Brothers, you could lose your annual bonuses as well, correct?
I mean, it really just depends on which clients and which scope of the business. It would be like a circumstances issue.
That was not my question, Ms. Williams. If Beeman Brothers were to lose their profits, then you could lose your annual bonuses, correct?
Yeah, if Beeman Brothers lost all their profits, I would definitely not be getting bonuses.
So you were more loyal to Shawn, who was taking clients and profits from Beeman Brothers, than your own employer, right?
I would not say that, no.
Your Honor, while I see time is up, may I ask just one more question?
You may.
Now, Ms. Williams, isn't it true that you were aware that other Beeman managers expressed their anger at Shawn's theft of clients?
Yeah, when people take clients with them, they always get a bit disgruntled.
Thank you, Your Honor. No further questions.
Is there a redirect?
No, Your Honor. There will be no redirect.
The witness may step down, and does the defense have any further witnesses?
No, Your Honor. The defense rests. Thank you.
And would the parties like a break before closing?
Yes, Your Honor.
Great. Why don't we do about a 10-minute break? We'll resume around 11:53 or so with closing arguments. Thank you.
Your Honor, the defense
Yes,
is
yes.
ready to proceed.
Great. And the prosecution ready as well?
Yes, we are, Your Honor.
Great. The defense will go first since the prosecution has the burden of proof, and I'll turn it over to Mr. Greenberg whenever you're ready.
Permission to proceed, Your Honor?
You may.
Please the court. Ladies and gentlemen of the jury, the prosecution gave you a lot of scary words to describe Shawn Miller. They called her a wolf in sheep's clothing, a seasoned hookworm, and a bandit who dangled the perfect bait in front of her clients. Yet you heard that the real bandit in today's case is Mr. Sidney Taylor, who concocted this scheme and then fled justice. It was Mr. Taylor who baited Shawn, promising her a work opportunity with a skilled Wall Street operative. And Mr. Taylor was the hookworm, leeching on an unknowing Shawn to bring in clients that he could then exploit. In today's criminal case, you must presume innocence unless given proof of guilt beyond any reasonable doubt. Ladies and gentlemen, this is the highest burden known to the law. But today, you did not hear the proof of guilt that the prosecution promised. Whether it's inferring contact between Shawn and Bernie Madlock that the prosecution never demonstrated, or passing off one vague statement as proof, the government tries to turn an incomplete case into a conviction. But there are too many holes in their story for you to return a guilty verdict. We are here to answer one main question about S&S derivatives. Was Shawn complicit in a Ponzi scheme? You did not hear any testimony or see any evidence which tied Shawn to this crime beyond reasonable doubt. That's because the truth of what happened at S&S is simpler than the narrative the government has put forward. Sidney Taylor, the Wharton grad and Wall Street whiz, was Dr. Details at S&S, handling investments, preparing financial statements, and employing his expertise to initiate a fraud scheme. Shawn, the extrovert who climbed up from the mailroom, was S&S's people person, handling existing clients, taking their calls, and bringing in new investors. You did not hear anything to contradict the idea that this was a division of labor at S&S. There are, though, three glaring holes which make the prosecution case insufficient to prove Shawn knew anything about fraud at S&S. You did not hear about any contact between Shawn and Mr. Madlock while Shawn was at S&S. You did not hear any references to fraud or finance in the single statement brought forward today, and you did not hear about any specific role for Shawn in this criminal enterprise. First, you did not hear about any contact between Shawn and Bernie Madlock while Shawn was employed at SNS. Ladies and gentlemen, it's the prosecution's theory today that all the fraudulent trading went through Bernie Madlock. Yet based on what you heard today, Shawn and Bernie Madlock never interacted throughout the entire course of the scheme. How is it possible that Shawn was in on this Ponzi scheme, but that she never so much as spoke to the person who made it possible? Ladies and gentlemen, the government, they can't explain this, and that's reasonable doubt. In fact, ladies and gentlemen, Investigator Holmes testified on cross that Mr. Madlock confessed credibly to his involvement in this scheme. In this confession, Madlock referenced Sidney Taylor, but made no mention of working with Shawn. Second, you heard about one conversation which the prosecution claims proved Shawn was actively partaking in the fraud at SNS. They promised you in their opening statement that this testimony would be their smoking gun. But critically, you did not hear any reference to fraud or finance in the 12 vague words that the government brought forward. Sidney's assistant, Pat Nolan, told Investigator Holmes about a conversation between Shawn and Sidney Taylor that she allegedly overheard in 2018. Nolan alleges in this conversation, Shawn said, "Way too easy, I say. He's doing a great job for us." Ladies and gentlemen of the jury, it's the prosecution's theory of the case that these 12 words prove Shawn was involved with fraud at SNS, that this is their smoking gun. But they can't just tell you that. They have to prove that to you. And what proof do they have to offer? Nothing. They give you only the testimony of Pat Nolan, who herself believed for years that this conversation was about the New York Yankees. You did not hear a reference to Bernie Madlock. You did not hear any mention of illegality. You didn't even hear a reference to financial trading that could substantiate Miss Nolan's guesses about this conversation. Ladies and gentlemen, that's reasonable doubt. Third, you heard that at a firm full of extraordinary illegality, Shawn only did the ordinary. You heard from Shawn that her job was to bring in clients. This would happen at any firm. I want to be clear, ladies and gentlemen, reassuring clients worried about a bad economy or advertising a firm's past success is not criminal or even unusual. You heard, though, that Sidney Taylor took charge of preparing fraudulent financial statements. You heard that Bernie Madlock produced confirmations for trades which never happened. You heard that Pat Nolan had the role of courier, bringing flash drives with illegal trading requests from SNS to Mr. Madlock. But critically, you did not hear any role for Shawn in this regular criminal routine. In fact, you heard that Shawn didn't have the technical knowledge to be a part of this scheme. You heard that she barely passed exams which licensed her to be a stockbroker. Meanwhile, you heard Sidney Taylor took exams focused on futures and derivatives and spent an extra year earning his MBA. Ladies and gentlemen, consider this for a moment. Why would Sidney Taylor include more people than necessary in his Ponzi scheme? If he could keep Shawn in the dark and keep the money flowing, why wouldn't he? That's reasonable doubt. Ladies and gentlemen of the jury, we are at the end of the trial. The government has put their best evidence and most compelling witnesses before you, and we're left with an incomplete case. You heard Investigator Holmes say that Bernie Madlock conveniently did not mention Shawn in his interview. Yet you heard that Investigator Holmes never felt the need to ask Mr. Madlock if Shawn was even in on the scheme. You heard that Investigator Holmes say that she conveniently could not find any evidence of Shawn delivering flash drives to Mr. Madlock. This shouldn't be a surprise though, as despite concluding that the flash drives were the key technical component of this Ponzi scheme, you heard that the investigator never felt the need to obtain or examine said flash drives. What you did hear about these flash drives came from Pat Nolan, who testified that she delivered them solely on Sydney's instruction, quote, whenever Sydney would tell her to. Not Shawn, Sydney. You heard Investigator Holmes assert that SNS's refusal to take client calls was a red flag. Yet you heard Investigator Holmes never felt the need to speak with more than one client. You heard that Investigator Holmes, despite being reliant on her interview with Pat Nolan, despite that being her smoking gun, never felt the need to speak with Shawn's assistant. And you heard that Investigator Holmes made one visit to SNS, but you heard that she never felt the need to try again and interview Mr. Taylor, who we all agree was at the center of this scheme. What you did hear is that Investigator Holmes believes people like Shawn cost her her job. Ladies and gentlemen, Investigator Holmes may not have felt the need to conduct an unbiased and thorough investigation, but the prosecution needed to prove to you beyond reasonable doubt that Shawn Miller was complicit in this scheme. And this investigation and this case is wholly insufficient for them to do that. They have failed to make Shawn Miller's guilt the only plausible version of events. You did not hear one single solitary piece of evidence that clearly connected Shawn to the fraud at SNS. Instead, you heard that Sydney Taylor concocted a scheme and orchestrated a system where no one but him, Bernie Madlock, and his assistant needed to know about the scheme. You did not hear that Shawn was a part of the scheme or that Shawn had knowledge of fraud at SNS. You did not hear anything close to the evidence needed to convict Shawn Miller. We ask that you find Shawn not guilty. Thank you.
Thank you. Prosecution ready to proceed?
Yes, Your Honor.
You may go ahead, Ms. Geller.
As children, we dream to one day become doctors, lawyers, or even bankers. But the defendant, Shawn Miller and Sydney Taylor, their childhood dream was simply to become rich like royalty. Together. And together, they orchestrated a scheme to line their pockets with millions, with the defendant as the hookworm that lured in the financial victims, and Sydney Taylor as the mastermind. Ladies and gentlemen, that word hookworm is not a scary word to distract you. It is an apt characterization of who Shawn Miller has shown this court that she is. While Sydney Taylor managed to make her way through some of the nation's best schools in pursuit of a financial career, Shawn was never far behind, taking the shortcut, becoming close with Wall Street's more unscrupulous characters, learning the ins and outs of illegal trading schemes, and most importantly, honing her interpersonal skills, the tool that would help her serve up the financial victims to the SNS scam. As the defendant and Sydney entered their dream, the Ashcotts were plunged into their worst nightmare. What was once their hopes of a peaceful retirement vanished into thin air after the defendant lured them in and swindled their $3.5 million nest egg. The defendant has shown this court today that despite her lack of financial education, she was well versed in the art of manipulation. Today, ladies and gentlemen of the jury, we have made clear beyond a reasonable doubt that Shawn Miller is guilty of securities fraud and conspiracy to commit securities fraud. Now, it is no small stretch of the imagination to see that Shawn and Sydney conspired along with Bernie Madlock and Pat Nolan to make themselves rich. A person is guilty of conspiracy when they agree with one or more people to cause the performance of intentionally felonious conduct. The defendants agreed division of labor with Sydney on the investment side of business, the defendant bringing in Bernie Madlock to help Sydney place the trades, and her poaching of the Ashcotts as clients for S&S were all acts to cause the performance of securities fraud. Your Honor and members of the jury, Pat Nolan outlines this scheme when she testified to the flash drive that was used to conduct this illegal trading scheme. S&S took advantage of the fact that flash drives were untraceable when both Shawn and Sydney sent Pat Nolan to conduct the illegal trades. Let's also not forget that we heard testimony here today revealing that Bernie Madlock admitted to the usage of flash drives to engage in illegal trading. With that, Pat Nolan's testimony regarding this conversation is telling. Pat also testified the defendant directly aided Sydney in filling out monthly investment statements and sending the false trade requests to Mr. Madlock. Additionally, Pat Nolan testified that Sydney said, "Did you ever think this could be so easy? If only they knew." And the defendant responded, "Way too easy. He's doing a great job for us." Your Honor, Pat Nolan testified that they were talking about Bernie Madlock and the fraudulent investment scheme that was occurring at S&S Derivatives. The defendant claims otherwise, but Your Honor, they were reviewing their monthly client investment accounts. Logic and evidence shows that the defendant was deeply involved and very much aware of the scheme. Now, let's address the securities fraud charge. As the court has seen through evidence presented today, the defendant violated the Martin Webb Act by making false representations and assurances to the Ashcotts, of which she either, 1, could have known the truth with reasonable effort, or 2, was clueless to the truth of her own statements, yet she made them anyway. We provide these elements only to show that whichever route the defense has chosen to take, that is, the defendant was absolutely clueless, or that she acted reasonably in confirming the soundness of the Ashcotts account, either of which would lead to a conviction. Your Honor and members of the jury, we even heard testimony here today that revealed that the defendant never knowingly sent out false statements. This in itself demonstrates her misrepresentations of S&S and her lack of motivation to know the truth about her partner's investment strategy. Even though she had the capabilities to do so, she simply never felt the need to check on her own firm's investment strategy. The false narrative that the defendant was oblivious to the illegality of both her partner's conduct and that of the very company she founded is incredible. Not only does the law require that the defendant exercise a reasonable effort to know the truth, which is a logical and reasonable public policy to protect consumers like the Ashcotts from financial predators like the defendant, but the defendant demonstrated today on the stand just how truly knowledgeable she is about her position and qualifications. She was well versed in what was required for investment companies to run properly. This is just another inconsistency with the defense's theory of her ignorance. She told us here today that she has a great memory, yet even has no idea where her own client's money is. She also admitted to providing unfounded assurances to Fran Ashcott's questions, consoling her with promises of preserving her investment should it be lost. When push comes to shove, Your Honor, and the worst situation rose upon the Ashcotts, the defendant made no mention of utilizing those methods of recovery for her investment, leaving the Ashcotts, barren and destitute. The defendant solicited and accepted money from the Ashcotts with the express intention that that money be invested in legitimate financial instruments, one of the overt acts. And after investing with the defendant and S&S, you heard here today that Fran Ashcott became concerned about the defendant's own investment strategy. Fran Ashcott was so concerned that she placed a call to the defendant. This time, Fran wanted to know about the nature of her investments. And how did the defendant respond, you may ask? She assured Fran that her investment was sound. However, Your Honor and members of the jury, Fran testified here today that her and her husband are now destitute and their entire life savings was lost by the defendant's fraud and conspiracy. In fact, expert witness Sharon Holmes today has testified in line with the defendant's misrepresentations, as it would have been practically impossible for a client to devise that their financial statements were false. The defendant was well aware of this and figured any inquiries into the inner workings of the account would have been easy to dismiss with mere platitudes. Even more, investigator Holmes has evidence to this court today that the weakening economy hurt SNS's well-oiled fraud machine when those simple reassurances started to fail. We even heard from expert defense witness and thorough auditor Nikki Penman that she had no idea what documents she was shredding at her former employer, Arthur Andersen. In fact, she explicitly said, "I don't know, and I'm not sure," when asked questions about conducting proper audits. Are we to trust the words of an expert witness who was unsure of her expertise, unsure of her own employment, and unsure of her own audits? Moreover, an expert who said on the stand that she wants the defendant, in this case, to be exonerated. Ladies and gentlemen of the jury, if this is who we are supposed to believe when it comes to auditing expertise, then it is truly hard to imagine that a proper audit was even conducted at SNS Derivatives. Based on her own personal actions, not to mention underlying bias, it is far more believable that Ms. Penman could have shredded the documents that revealed the defendant's fraud in today's case. Your Honor, we contend that the evidence is clear that the defendant and her lifelong best friend, Sydney Taylor, were co-conspirators in a variety of schemes. First, the defendant and her partner in crime, literally, conspired to commit a breach of contract by having Sydney orchestrate trades with SNS while still under contract with Terrell Hinch. Second, the defendant provided unfounded assurances to her own client's concerns about her account without even reviewing her own firm's investment strategy. Lastly, the defendant and her now convicted co-conspirator conspired to commit securities fraud in this obvious Ponzi scheme. Accordingly, Your Honor, the defendant, in so many words, can be defined by the simple word, fraud. Whether it be committing securities fraud in an illicit scheme with Sydney Taylor, or simply making herself out to be someone that she was not at the expense of the Ashcotts.
You have 1 minute.
Today, we ask this court to consider every element of the law. We have proven beyond a reasonable doubt that the defendant is guilty of securities fraud and conspiracy to commit securities fraud. We respectfully request that the members of the jury consider the facts of today's proceedings and render a verdict of guilty on all charges. Just like it only takes two to tango, it only took Shawn Miller and Sydney Taylor to hatch a Ponzi scheme. Thank you, Your Honor, and thank you, members of the jury.
Thank you, Ms. Geller. That was a tremendous performance by everyone. I'm going to take a break now to review my notes and my scores, and then we'll resume in a little bit. I see Oliver popping up. Anything, Mr. Young, you wish to add?
Yeah, well, I'll talk to students with your indulgence or when you come back on, Your Honor.
Sounds good.
Okay. Thank you. I believe everyone is back, Your Honor. Is that correct? Okay, great. So, good afternoon, everyone. I am Oliver Young, and I chair the high school mock trial subcommittee, and the committee that prepares the mock trial materials each year. On behalf of the New York State Bar Association and the New York Bar Foundation, I wish to congratulate all 8 teams that competed in the statewide finals yesterday. All of the judges expressed their great admiration for the teams and for the tremendous effort the teams put into preparing and trying this case. I especially wish to congratulate the two teams competing today for the championship. You have reached the pinnacle of the New York State mock trial competition. This year, you are the two best teams from all of the teams across the state that participated in the 2022 tournament. While only one team will prevail today, both teams should be proud of their accomplishments. And while this was not the ideal setting for a trial, this virtual world, all teams stepped up, dealt with the technology issues, and acquitted themselves handsomely. I want to thank Judge Cronan for presiding over this match. Judge Cronan is a federal court judge for the Southern District of New York. Prior to taking the bench, he served as the acting assistant attorney general and principal deputy assistant attorney general of the Department of Justice Criminal Division, where he supervised over 600 attorneys and oversaw the criminal division's nationwide prosecutions of securities and financial fraud. So the judge knows a thing or two about the subject matter of this case, of our mock trial case. He also oversaw the prosecutions of public corruption, transnational organized crime, international narcotics trafficking, cybercrime, intellectual property offenses, human rights violations, and other major federal crimes. I believe Judge Cronan has finished tallying the score sheet and will announce the prevailing team shortly. So, Judge Cronan, thank you very much for your significant contribution to today's endeavor and to the high school mock trial program. The judge will now make some comments to the teams and before announcing the prevailing team. So Judge Cronan, thanks again. We appreciate you today.
Absolutely. Thank you so much. And thank you to having me and to the teams who just did a truly tremendous job. I really don't have very much to say, and certainly not in the area of criticism, because both teams were extremely well prepared and put together very effective cases from the start. I mean, I thought both openings had excellent themes. The prosecution talking about magician, sleight of hand, defense with the "you will not hear" theme, focusing on the absence of evidence, which really was the defense's strongest point here, I thought. And you return to that very effectively in closing. Both the refrain "you will not hear" and focusing on the absence of proof. Mr. Young just mentioned that my prior job, I had oversaw financial crimes prosecutions. These are tough cases to prove from the prosecution, and they normally they would entail a lot of evidence and probably weeks of evidence. So it's a challenge when you have such a small packet of stuff to put it together like did, but both sides did a tremendous job. All the jury addresses were well structured and thought out. The witness examinations were also clear and well organized. All the witnesses were so prepared and extremely convincing. One of the hardest things for a trial attorney to do, even the most seasoned trial attorneys, is cross-examination. And everyone here did a great job. It's very hard to, with a prepared witness, to to get the answer you're looking for, but you all did a good job of focusing in, trying to get the answer, and then moving on, not giving the witness too much time to explain the answer. The rules of evidence are hard, again, even for the most seasoned trial attorneys, and you all had a great handle on them. Judges handle stuff differently. Other judges may have come out very differently than I did on some of the rulings. Some judges sustain more of the narration, asked and answered, compound question objections. My practice is I usually allow more leeway in those questioning unless I think it's getting abusive, unless it's intended to delay. But you have another judge in the courthouse I'm sitting in right now, and the rulings could be different. And that's kind of the nature of trial litigation. They were interesting, and I could tell really thought out strategic choices made as well. One that stood out to me was the defense allowing information about Taylor's conviction to get in, but that fed into the theme the defense was arguing, that that Taylor is the one, not Miller, who was responsible for this. So again, you all did a tremendous job. You should be so proud of yourselves. I know there are a lot of people joining. I don't know if any other teams are listening as well, but congratulations to you too. I'm sorry we did this remotely. I extend an invitation to any of you, if you're end up in if you're in New York City and want to come over to the courthouse here, I'd be happy to show you around here. If I have anything interesting going on in court, I'm happy to have you come watch and talk about it. You guys can get my email from the court website. If you again, my name is John Cronan, Cronan, and our email here is my last name, Cronan, NYSD Chambers at nysd.uscourts.gov. Again, that's on the website, but Cronan, Cronan, NYSD Chambers at nysd.uscourts.gov. And again, if you're ever around, I'd be thrilled to host you over here. So today was a blast for me, and doing this always is, up until one point, which is right now, when I have to somehow pick a team that has prevailed on points. And I have to say it could not have been closer, and it is it's a shot to my stomach that I have to pick one of the two of these phenomenal teams. I would love to have both of you in my courtroom any day of the week trying to case in front of me. But I did find that the defense had a slightly higher final score. So congratulations to the defense team. Again, that is no reflection at all on anything other than two tremendously talented teams appearing before me. So congratulations to all of you. And maybe we could, I don't know, I guess, give a remote round of applause to both the teams.
Great job, everybody. Thank you, Judge, for being here again this year. We really appreciate you taking the time. And I'll be knocking on your door again next year if you're still willing. Hopefully you can come to Albany next time.
Absolutely, I would love that.
Okay.
I love that.
Well, thank you, everybody. This does conclude the trial. Have a great holiday weekend, and hope to see you soon in Albany next year, hopefully. All right, good luck, everyone.
Congratulations to both teams.
Thank you.
Congratulations to both teams.